Okay. Good morning. The time is now 8:30, and I'd like to call the June 14th, 2024 meeting of the Energy Facility Siting Council to order. Mr. Secretary, could you please call the roll?
Kent Howe,
Here.
Marcy Grail, Marcy Grail. I'll just make note for the record that Councilmember Grail is present virtually. Ann Byer. Here. Richard Devlin.
Can you hear me?
Yes.
Yes, Councilmember Devlin, we can hear you.
Okay, I still have no video for some reason.
Katie Imes.
Here.
Mr. Chair, you have a quorum.
Okay. Thank you. Are there any agenda modifications?
Mr. Chair, I have a recommendation for one agenda modification. So agenda item E is the Boardman to Hemingway Amendment Number 2, council review of the draft proposed order. Agenda item F is the Sunstone Solar Project Hearing Officer appointment. Since Councilmember Grail is recused on the Boardman to Hemingway project in total, and she may need to leave a little bit early today, I request that we swap agenda items E and F. Since agenda item E is a hearing officer appointment and should only take about 5 minutes, and it's an action item, and it would be helpful to have council member Grail's participation. That shouldn't change really anything in terms of the agenda, but that would allow her to leave early if she needs to and still allow that action item to occur.
That sounds great.
Thank you.
Okay, with that modification, we'll proceed. I have the following announcements. Please mute your phones, and if you're joining us by phone and receive a phone call, please hang up from this call and dial back in after finishing your other call. For those signed on to the webinar, please do not broadcast your webcam. For agenda item D, public comment, there are 3 ways to let us know you are interested in providing comments to the council. For those in person, please fill out a registration card available on the table. For those using the WebEx, you'll need to use the raise your hand feature. And for those on the phone only, you'll need to press *3, which will alert us that you want to speak. We'll go over these options again during that agenda item. If you want to receive future email notifications of council meetings, project milestones, or rulemakings through our Click Dimensions program, you can do so by clicking on the link in the agenda or on the council webpage. Look for the green box on the right-hand side of the page that says sign up for email updates. You're also welcome to access the online project mapping tool and any documents by visiting our website. Please note that the audio and video of this meeting is being recorded and may be posted to the council's website following the meeting. Energy Facility Council meetings shall be conducted in a respectful and courteous manner where everyone is allowed to state their positions at the appropriate times consistent with council rules and procedures. Willful accusatory, offensive, insulting, threatening, insolent, or slanderous comments which disrupt the council meeting are not acceptable. Pursuant to OAR 345-011-0080, any person who engages in unacceptable conduct which disrupts the meeting may be expelled. So the next item is the consent calendar. We first have approval of the April 19th, 2024 meeting minutes. Do I have a motion? Councilor Byer?
Chair Howe, I recommend that we approve the April 24th SEC meeting minutes as
Second.
presented.
Okay, we've got a motion and a second to approve the, is it 24th or 19th?
19th.
That,
Oh.
yeah,
I correct my motion.
yeah, the April
Thank you.
29th, 2024 meeting minutes.
April 19th.
Did I say 24?
You
I'm
said
sorry.
29th.
Okay, April 19th, 2024, meeting minutes for approval. Mr. Secretary, could you please call the roll?
Ann Byer,
Yes.
Kent Howe,
Yes.
Richard Devlin,
Yes.
Katie Imes,
Yes.
Marcy Grail,
Marcy, I'm not showing a microphone for you, so I think you might want to sign out and come back to the meeting again.
minutes passed. We had
Okay.
enough, without, even without Councilmember Grail, that was 4 votes, so
Yeah.
motion carries, Mr. Chair.
Okay, so Council Secretary report, please.
All right, I will first start with one project update. So Chris, Chase, and Nancy held the complete application public informational meeting for the Sunstone Solar Project at the Port of Morrow in Boardman last Wednesday, the 5th, excuse me. Proposed project is 1,200 megawatts solar PV project on 14.75 square miles in Morrow County, approximately 15 miles south of Boardman. Outside of the Department of Energy, council members, and the applicant team, there were 13 people physically present and 20 people on the webinar. Councilmember Imes attended in person and Councilmember Byer attended virtually. Thank you for the extra time you spent doing that. And I would just ask if you have any thoughts or impressions you'd like to share, feel free to do so. If not, that's okay too.
Think about it.
Okay. Okay, thank you. Moving on, if you want to advance the slide, please. So we do have one compliance update. On June 3rd, a worker at the Portland General Electric owned Bigelow Canyon Wind Farm found a wind turbine nose cone and 2 of the connector turnbuckles approximately 150 feet from the turbine in a field. 2 of the turnbuckles were still connected to the turbine. 2 have not yet been found, at least when PGE reported the incident to us. PGE reported the incident to the department within 72 hours. This is consistent with condition number 37 of the site certificate. No injuries were reported and no damage to the wind turbine was reported, and it is still operational. Cause of the detachment of the nose cone is still under investigation by PGE. And then as a reminder, the Bigelow Canyon Wind Project is 450 megawatts, includes 217 wind turbines, and is located in Sherman County. So really don't have anything more at this point because it's a fairly recent incident. And then last on my list is the July council meeting. So that's currently placeholder for July 18th and 19th. We don't know, we should know as of early next week whether we're going to need to have a meeting or not. And so we will contact council members. We will check in with Chair Howe about holding a meeting, but we're not 100% sure, but we should be by early next week, and then we'll reach out to you with that. And
Mr. Chairman.
Councilor Devlin?
Yes, for the secretary, you had mentioned in the last meeting a possible meeting in Clatskanie. Do you know what project that would be associated with?
Yeah, Councilmember Devlin, we were thinking that would be the July meeting for the public hearing on the draft proposed order for missed amendment
Oh, okay.
13. So that's the missed underground natural gas storage facility. They currently have an amendment which is replacing a lot of equipment and adding some additional equipment. So it will be related to that. At this point, we are not going to be holding the meeting in Clatskanie. Draft proposed order won't be ready yet. So I think based upon a couple of things, including today's meeting, we'll determine whether we need a meeting in July. If we do need a meeting in July, it would likely either be here in Salem or just virtually, depending upon the agenda items.
Well, thank you for that clarification. I thought it was far too early for any hearings about a proposed transmission line in the Columbia River, so.
Yeah, and that one's not, it wouldn't be a transmission line. It would be, yeah, it's underground natural gas storage. So
Yeah.
numerous components, but
Mr.
Oh, go ahead.
Mr. Secretary, I know that. I was trying to place Clatskanie and I just couldn't immediately place it. So I understand now.
Right. Okay, thank you. And Chair, that concludes my report.
Secretary, if I might provide a brief update on litigation.
Yep.
Patrick Rowe, DOJ, update on the appeal of the Boardman to Hemingway Amendment 1. So I will refresh your recollection as I've been doing in recent meetings. This was, I think, probably about 10 months ago now. You denied a request for contested case on Boardman to Hemingway Amendment 1, and you approved the amendment. Ms. Irene Gilbert appealed the denial of the contested case. She did not appeal the approval of the amendment. She appealed the denial of the contested case to Circuit Court. So this has been going through a lot of procedural machinations since initially my colleagues at DOJ sought to transfer it from the Circuit Court to the Supreme Court, which has, as you know, jurisdiction by statute over your decisions on a site certificate. The statute does not explicitly address, does not address at all who has jurisdiction for your decisions on a request for contested case. The Circuit Court denied that. Then we went directly to the Supreme Court and asked them to take it up. That's probably the last update you got from me. The Supreme Court said, we're not going to take it up, but this council's decision on the site certificate is final because Ms. Gilbert had not appealed that aspect of your order. So then it went back to the Circuit Court. And then at Circuit Court, most recently, Idaho Power, as well as my colleagues at DOJ, sought to dismiss it. And they said, given that the Supreme Court has said that the decision on the site certificate is final, this case is moot. There's no reason to have a contested case. What would we be arguing about? The Circuit Court unfortunately denied that motion, but did not offer any rationale. So right now we're still in Circuit Court, and we are deciding whether to just stay there and argue whether, present the case there, or once again ask the Supreme Court to take it up. That has yet to be determined what our next step will be.
That was interesting. Thank you. Yes, Councilor Byer.
So is there a statutory fix to what do we do with appeals of contested cases, or do we just wait to see how this shakes out?
I have recommended to the department that they go to the legislature and ask for a statutory fix, and that's up to the department as to whether or not that they'll do that.
Okay, thank you. It seems like this could come up again.
Yeah.
Yeah, and we are looking into that question right now.
Thank you, Council Rowe. So the next item is the Wagon Trail Solar Council review of the draft proposed order. It's an information item, and Chase McVeigh Walker, Senior Siting Policy Analyst, will take the floor here.
Okay. Good morning, Chair Howe, members of the council.
Morning.
For the record, my name is Chase McVeigh Walker, Senior Siting Analyst with the Oregon Department of Energy. today's agenda, as Chair Howe just mentioned, is council's review of the draft proposed order for the Wagon Trail Solar Project application for site certificate. Today's agenda item is an opportunity for the council to provide comments to staff on the draft proposed order and the issues raised on the record of the public hearing for staff consideration in the proposed order. In hopes of appropriately organizing my presentation, I will first briefly describe the proposed site and facility and the procedural history, and then we'll provide an overview of the draft proposed order and the comments received during the DPO comment period. I'll do my best to adequately address and characterize each issue brought up, and will allow council to discuss and provide recommendations on those issues. And to be clear, today's agenda item B is not an action item. It's simply an information item and an opportunity for council to provide comments to staff for consideration in the proposed order. Next slide, please. Oh, yeah. So this slide is the overview I just went over. Next slide, please. Okay. The Wagon Trail Solar Project is a proposed solar photovoltaic energy generation facility proposed by Wagon Trail Energy Center LLC, whom is the applicant. The applicant is a wholly owned indirect subsidiary of NextEra Energy Resources LLC. The proposed facility would permanently occupy up to approximately 3,685 acres of private exclusive farm use zone land located within a site boundary of 7,450 acres. The proposed site would be located entirely in north central Morrow County near Lexington, Oregon. Proposed related and supporting facility components include a 500 megawatt lithium ion energy storage system, 2 collector substations, a 34.5 kilovolt collection system, an operations and maintenance building, 0.6 miles of 230 kV transmission line, 4 meteorological stations, met stations, and 4 construction staging areas. The next slide I've called out the location of these components. Next slide, please. Oh, I guess not. Okay, well, we'll go to the next slide then. Oh, this is fine. Procedural history. Okay, well, the procedural history for the Wagon Trail Solar Project starts on November 3rd, 2020, when the department received the notice of intent to file an application for site certificate for the proposed facility. On November 20th, 2020, the council appointed the Morrow County Board of Commissioners as a special advisory group for the proposed facility. And on November 25th, following the NOI receipt, the department issued a public notice of the NOI. In January of 2021, the department held a public information meeting. And then on June, the second line here, on June 11th, 2021, the applicant submitted an amended NOI to the department to address site boundary modifications. And subsequently, the department issued a public notice of the amended NOI. Then in August of 2022, the department received the preliminary application for site certificate. The department issued additional requests for additional information in November 2022, February 2023, and December 2023, to which the applicant responded to. After reviewing the applicant's responses, the department determined that the PASC, the preliminary application for site certificate, to be complete on December 22nd, 2023. And following that completeness determination, the applicant filed a complete application for site certificate on January 3rd of this year, 2024. On May 7th, the department issued the DPO for the Wagon Trail Solar Project, which initiated a 31-day comment period. Chair Howe conducted a public hearing on the DPO at last month's FSEC meeting on May 30th at the Portomoro Riverfront Center in Boardman, Oregon. And the record was kept, the deadline for the public comment period was June 7th, but the record was kept open until June 10th for the applicant to respond to comments received. On June 10th, which was this past Monday, the applicant requested an extension until June 11th, a 24-hour extension to respond to the comments. And we're here now on June 14th with FSEC's review of the DPO and the public comments. Next slide, please. Okay, this is a process chart that I'm sure everyone here is familiar with. This is the energy facility siting process, application for a site certificate chart. There's 7 major steps to the ASC siting process. The first being the notice of intent, followed by the project order, the application step, which includes the preliminary application and complete application. And then the 4th step, which is highlighted with the red rectangle, is where we are today at the draft proposed order. Generally, the draft proposed order is the Oregon Department of Energy's initial findings of facts, conclusions of law, and recommendations to council on whether or not the facility would comply with all applicable requirements. And following the public hearing, council reviews the draft proposed order during a council meeting, and based on direction from council, ODO in the next step would issue a proposed order and a notice of contested case. The proposed order is staff's revised recommendations based on comments received. And for the contested case, the second to last step, only those persons who raised a relevant issue in person at the public hearing or in writing by the comment deadline on the draft proposed order may participate in the contested case. The contested case process step is run by an independent hearing officer. And following the contested case process, FSEC will review the hearing officer's recommended contested case order and issues a final order approving or denying the application for a site certificate. And that is the last step of the process. Next slide, please. This slide is representative of council's scope of review. As I mentioned earlier, today is an opportunity for the council to provide comments to staff on the DPO and the issues raised on the record of the public hearing. The next step in the process will be for the department to issue a proposed order, taking into consideration the comments of the council and comments on the record of the hearing of the draft proposed order and any agency consultation. In conjunction with the issuance of the proposed order, the department will issue a notice of contested case. Does council have any questions for me at this point on scope of review?
Yep. Councilor Himes?
I just want to thank you, Chase. I just wanted to make mention of the, no?
Just, there was the, you see the chevron, it wasn't lit.
Okay. Thank you, Chase. I just wanted to make comment of the very short turnaround for council, for the review process. I didn't get a chance to review all of the comments just because of the very short time frame. And so I just wanted to mention that to the council and see if how everybody else felt about the review process this time around. I feel like I was not able to adequately review all of the material and really give good feedback for the process. So just want to make that known. Thank you.
Secretary Cornett.
For the record, Todd Cornett, just for kind of process clarification, yeah, this was a sort of a tight turnaround in terms of the time frame between the last council meeting and this, and then obviously the public comment time frame deadline, and then the response by the applicant. So essentially, you know, we wanted to make sure that it was on this agenda so you could to at least begin reviewing it. But ultimately, it is your choice whether you feel you've had enough time to review information. I think it's worthwhile for Chase to go through and do the entire presentation. I think once he concludes that, you can have some conversations and decide if you feel like you've had enough information based on the presentation to evaluate the comments and the responses and provide your responses to us. Great, you can do that. We'll move forward. If you only feel like you've had the ability to deal with some of them, but not all of them, you can simply not conclude this agenda item and continue it to the next council meeting. That's entirely within your choice.
Thank you, Secretary Cornett. Yeah, I was okay with the short turnaround, knowing that this was review only. If this were action item, then it would have been tight, but I'm okay with proceeding with the review, and I think we'll be able to get into the details with this review, and I think that'll help Councilor Imes a lot in understanding what the issues are. And then if we still need some more time, you can ask for that and we'll get it. So,
Thank you.
yeah. Okay. Okay, back to.
Okay, thank you. Next slide, please. For the record, Chase McVeigh Walker. So during the DPO public comment period, which was a 31-day comment period spanning May 7th through June 7th, there was a public hearing held on May 30th, and at the public hearing, 4 public commenters provided testimony and 1 reviewing agency. And we also received during the prior to the deadline of the comment period, we received 2 written comments, one being a public comment and one being of a reviewing agency. And as I mentioned, the certificate holder responded to all of the comments this past Tuesday on June 11th. And all of the comments and the reviewing agents and the applicant's response to comments were provided to council in the supplemental staff report as an attachment to that staff report. And in that supplemental staff report, the department also, to the best of our ability, summarized the comments in a table. Which leads me to my next slide. To the best of my ability, I broke down the comments received and the issues raised into 6 issues. There were comments related to vegetation management within the solar array, and soil stabilization, ground contamination from the solar array, reviewing agency coordination, goal 3 exception, justification and mitigation, and the applicant's organizational expertise. And I'll try to address these topics when I get to their applicable standards. And I'm not going to, well, we can go to the next slide. For this review of the DPO, I've chosen to not review every single standard, but rather present the standards that issues were raised in or were more unique in findings. These standards on the screen, the department doesn't anticipate any substantive changes from the DPO to the proposed order. So that's why I haven't included them in this slide deck. That said, if there's particular standards that you'd like me to address, I can do my best today, or if this agenda item is extended, I can come back and present on it at the extended time in the future.
Counselor Byer.
Thank you. Chase, I just looking at your summary of issues, we didn't receive public comments on these standards. Is that correct?
Yeah, correct.
Thank you.
And there's standards that are not listed here that I have included because I thought they were interesting, but they didn't have public comments, but I thought that they were interesting nonetheless. Next slide, please. So we'll kick it off with organizational expertise. As I mentioned, the applicant for this proposed facility is Wagon Trail Energy Center LLC, and it's a project-specific LLC and a wholly owned indirect subsidiary of NextEra Energy Resources LLC. In their application, the applicant indicates that they will rely on the expertise of their parent company, NextEra, and that NextEra has 175 energy facilities in 36 states and 4 Canadian provinces as of year-end 2019. NextEra subsidiaries already operate FSEC-approved facilities in Morrow County, the Wheat Ridge Renewable Energy Facility 2, Wheat Ridge Renewable Energy Facility 3, State Line 1 and 2, and that's not in Morrow, I believe, and Van Sickle 2 Wind Energy Facility, Umatilla. Sure.
Counselor Byer.
Thank you. I know maybe in the West End Solar or one of the other projects in either Morrow or Umatilla County, we asked for a letter from the developer showing the nexus, the relationship to the parent company. And I don't recall if we have a similar condition on this project. I can't remember which analyst worked on that project, but I know that we got an extra letter kind of defining that. Yeah, I think it was, I don't know if it's as strong as a guarantee, but just establishing that relationship. So if you could just check the conditions for organizational expertise. Thank you.
Regarding organizational expertise and comments received on the record of the DPO, there were multiple commenters that expressed their support for NextEra as a company, as well as for the Wagon Trail Solar Project. And those commenters and comments. With those comments, the department doesn't recommend any changes be made to the proposed order. It just was their support for the company. Next slide, please. Oh,
Since Councilmember Grail is having audio issues, she texted me and said, can we get a current number for the future? So going back to the slide, so the end of 2019 is a while ago, so curious to see if the numbers have grown or lost based on the facilities. So that's something we can do as well, is make sure that we get a more current number rather than 2019.
It's 175.
Correct. Yep.
okay. The soil protection standard, this is on the DPO pages 43 through 49. And this standard requires that council find, taking into account mitigation, that the design, construction, and operation of a facility are not likely to result in a significant adverse impact to soils, taking into consideration soil risks such as erosions and chemical spills. In the application, the applicant's evaluation of potential adverse impacts considered the entire area of the solar array, approximately 3,641 acres, to be permanently disturbed. And so this is going to relate to a comment we received, including the O&M building, substation areas, and the battery storage areas. The total area of disturbance would be 3,684.9 acres. At the public hearing, a commenter, Mr. Krebs, commented on the record, both in oral testimony and via a written handout. And his comments related to differing approaches to vegetation management within the solar array, where one site appeared to use chemical application and a second used a vegetative management approach for long-term soil impacts. The department agreed that the applicant did respond, and the applicant's response was provided in the staff report, and the department agreed with the applicant's response that vegetation management applies across multiple standards: fish and wildlife habitat, land use, and the wildfire prevention and protection standards. But the department disagreed that the vegetation management requirements of these plans is designed to protect soil and erosion potential within the facility fence line. So as a result of Mr. Krebs' comment and our evaluation of the applicant's response, the department is going to coordinate with the Department of Environmental Quality and Department of Agriculture on a vegetation management approach that would address impacts within the solar array that are not permanently disturbed areas. And so I think right now we would be recommending a new or an amended condition to be incorporated into the proposed order to ensure that long-term vegetation management, that a long-term vegetation management strategy be designed to ensure that site stabilization and soil protection for areas within the fence line that are not occupied by permanent infrastructure. So we would want to we foresee additional coordination with DEQ and Ag to come up with these strategies for areas within the fence line that were designated a permanent disturbance, but aren't occupied by actual infrastructure. So like the areas between solar arrays, like in the rows specifically. So that would be our recommendation in response to Mr. Krebs' comment, would be further consultation with our sister agencies to come up with a strategy for these areas of non-infrastructure and permanent disturbance. Okay. Please.
Yeah. Counselor Byer.
So there'll be excuse me, but I hope I have this right. There'll be an explicit condition requiring that ongoing consultation with the Department of Ag and Department of Environmental Quality.
I think that we would,
For the record, Todd Cornett, in response to the comment, we're going to work with them now.
Okay,
So this is not a permanent condition where we would work with them throughout the life of the facility.
Got it.
This was really response to the comments that we received to see, do we have adequate findings or conditions currently, or should we make changes to those in the proposed order? That's really what this is about.
okay, great.
So
Thank
what
you.
the outcome of that is to be determined. We haven't come to an absolute conclusion as to what changes should be made. That consultation with those agencies has to occur first.
Okay, so we would expect some kind of findings in the final order,
in the proposed order,
in the proposed order. Thank you, thank you.
that would reflect a vegetative management strategy for these areas of non-impacted areas, but within the fence line.
Mr. McVeigh Walker. Is this the first time that for solar arrays, there's been an interest in trying to vegetate the non-structurally impacted areas? Are we kind of breaking new ground here, agrivoltaics or whatever?
I believe so, yes. I mean, yeah.
Back there. This is Sarah Esterson, Senior Policy Advisor for the record. I mean, this particular issue was a very big issue for the Obsidian Solar Center project because of the soils and the erosion potential and the high value irrigated farms and proximity. That project hasn't moved forward yet, but we really expanded like site stability before disturbance and anyway, so we went there with that project. Again, we haven't implemented it. And then as Chase's staff report sort of outlined, I mean, vegetation management within the fence line is addressed in part and under the wildfire mitigation standard, but that's more about making sure it's like away and almost incentivizing
not
gravel and more bare ground, but we don't want that from an erosion soil perspective. So, and I mean, a lot of the facilities that are moving forward, which we actually don't have that many solar, but you know, they're proposing sheep. So we know that there's vegetation there. We just don't know if it's being thought through from the perspective of site stabilization. So that's where we're kind of going with it, which is, I mean, we have a lot of guidance from what the 1200C does in terms of seeding with a native seed and getting a certain level of cover before you say, okay, the site's stable. So we have some models to kind of work with DEQ and Department of Ag. So it won't be mind blowing, I don't think, what we come up with.
Thank you, Ms. Esterson.
It will be mind blowing.
Well, yeah.
Next slide, please. Okay, going into land use. The land use standard requires that council find that a proposed facility complies with the statewide planning goals. Council may find compliance with statewide planning goals if the council finds that the proposed facility complies with applicable substantive criteria from the affected local government's comprehensive plan and land use regulations that are required by the statewide planning goals and in effect on the date the application is submitted. The applicant in their application requested council's consideration of a reasons exception I'll go into more on that goal exception on the next slide and the reasons the department and the reasons that the department considered appropriate. Next slide, please. So in the department's DPO, there were 4 reasons that the department recommended be considered appropriate for consideration of a goal 3 exception. The 4 are that the facility would be locationally dependent, would have minimal impacts to agriculture, it would have agricultural related economic benefits, and would have minimal impacts to other environmental resources. In comments received on the record of the DPO, Morrow County agreed with the department's analysis that the facility is locationally dependent and that the facility would have minimal impacts to other environmental resources. However, Morrow County's comments expressed concern regarding the department's recommendation that council find that the proposed facility would have minimal indirect and induced impacts on agriculture as a reason justifying granting a goal exception. Now, Morrow County's comments on the DPO or any of their prior comments on the record they didn't address any specific insufficiencies in the analysis or evidence provided in Exhibit K. And so for that concern that the proposed facility would not have a minimal indirect and induced impact on agriculture, the department cannot further evaluate the issue as there wasn't any what was provided on the record in Morrow County's comments on the DPO and past comments, there was insufficient analysis. So yeah, we're recommending that we can't further evaluate that comment in that particular part of that issue.
Councilor
Please.
Byer.
Just another question on the minimal impacts to agriculture, and I guess it means I need to go back and look at attachment K, but I think understanding how the applicant described the minimal impacts to agriculture, I think we sometimes look at the acreage affected and just say, oh my goodness, but that's not the whole story. And I guess it's just making sure we have findings related to this issue, if we accept this issue as part of the reasons exception, to cite some of the evidence that the applicant has provided on those minimal impacts, which is a really squishy term, but does that make sense?
Secretary Cornett.
Yeah, thanks, Councilmember Byer. That's exactly right. So, some standards, are more prescriptive than others. With this is a goal exception. In a goal exception, there are 3 opportunities. Either it's physically, it's built upon, it's physically committed, or there's the reasons exceptions. And so everybody uses with solar the reasons exception. So, and it is the applicant's argument to make, burden to provide evidence that there are, that they can justify, there's a reason that they should give an exception. So there's not a definitive prescriptive way to do that. Obviously, we've seen over time, similarities in requests and applications, but in this instance, and this particularly in the minimal impacts to agriculture, the applicant has submitted their request, they've used evidence to justify that. At this point, the department has evaluated that and agreed based on that evidence. But that's exactly what we're doing here now is it's important. We obviously heard comments by the county. They had some concerns about whether there is sufficient evidence to justify that. As Chase said, there was maybe lacking the specificity provided by the county for us to really evaluate why they're concerned about it. And so, but this is exactly what the council is here today to do is, do you agree with the applicant's submittal and the department's response, and determination that that is a justifiable reason, one of 4 justifiable reasons, not the reason, but cumulatively one of 4 reasons. But that's exactly what you're here today, or should you want to continue this?
Counselor Byer.
Thank you. That's what I needed to hear. And I think it's important, as you pointed out, that they are using multiple reasons. And there's nothing in statute or administrative rule that says any particular reason trumps all the others. They're sort of equally weighted, or we could weigh them in any manner that we wanted to. But just to make sure that in the posed order that we're very specific about the evidence that the applicant has provided, because that allows us as a council to say, yeah, got it right. That condition is perfect. So thank you.
A second issue that Morrow County brought up and expressed concern with regards to the Goal 3 exception and the department's evaluation was the department's recommendation that council find that the proposed facility would have an economic benefit related to agriculture as a reason justifying granting a goal exception. And as I mentioned, the applicant did provide a response to all of the comments received and actually a letter in response to Morrow County's comments. And part of the applicant's justification for this reason was based on agricultural related mitigation that they intend to implement to offset impacts based on a quantified dollar per acre formula. The county argued that in their comments on the record that based on another project, the cost per acre utilized to determine the funding needed to offset agricultural impacts was inadequate for this facility. And in response to that, thought the county was comparing the analysis provided in this application for site certificate to another facility that has not yet even reached the DPO phase, nor has been released for public comment and been approved by council. And so trying to compare this facility where we are in the process to another facility that's not even to where we are in the process, we don't believe that you should be comparing this to something that's not approved or has even been reviewed yet. And so we, in our staff report, suggest or recommend that this comparison not support the reason that, or not support Morrow County's comment that the economic benefit related to agriculture is inadequate for Wagon Trail. So a little confusing, but I mean, the crux of how we were evaluating their comment was we didn't think it was appropriate to be comparing this project to another project, and also this other project isn't at where we are in our process. So,
Yeah, Counselor Imes.
I just have a question, Chase. So let's say that they were not comparing this concern to another project. Is it still relevant? Are they still able to bring it up? I mean, I understand that you're saying that you're not looking at the issue any longer because we shouldn't be comparing it to a project that's not even gone through, is still in the very, premature phase. But are we still able to look at the comment and address it regardless of that comparison?
Secretary Cornett.
For the record, Todd Cornett. Thank you, Councilmember Imes. In short, yes, in a way. So the specific kind of comparison between this project and the other project that's not reached the stage, that gets difficult because there's no record really of that yet. You haven't seen it, you haven't evaluated it, the public hasn't seen it, they haven't evaluated it. There's no decision. However, the question of, is the evidence on this project with the dollar per acre sufficient to justify that as one of the reasons? That you absolutely can look at. You can come to the conclusion, with your analysis to say, that's either adequate. So the applicant said, for compensatory mitigation for agricultural impacts, they provided a per acre dollar amount. Our analysis for the department was that was adequate to justify one reason, the economic kind of benefit or the mitigation. You could come to a different conclusion and say, we don't think that is adequate, and you could dismiss that as one of the reasons to justify it. You would then have to look at the combination of the other reasons to say, are those in combination adequate enough to overall justify the reasons exceptions? So in short, you can look at the base of the question. Does the applicant provide sufficient information, in this case, mitigation per dollar acre, mitigation enough to justify that as being one of the reasons or one of the elements of the reasons exception? So yes, in short.
So we're not dismissing this.
No.
Okay. And then also, I believe at our last meeting in Boardman, May 30th, we had that public hearing where Wagon Trail gave comment, and I believe they actually did touch on this subject. So I feel like it is in the record and that we should be able to speak to it.
Just from a procedural standpoint, even though this issue could not have been raised at all by the public or by the applicant, under your review, it is still under your authority to review this question. If nobody had brought it up and you still had a concern about this, and this is why, going back to the other slide that Chase had shown, here's all the standards that we're not going to talk about because nobody brought up comments on these. You still, within your review of the draft proposed order, you have the authority to review everything and anything that you want to review. So regardless of whether those were brought up or not. Now, it certainly helps because it identifies what are the major kind of issues or concerns that are raised by people. That's typically the driver for us to bring these up to you. But Chase even sort of said, there are some things, some standards we're going to talk about that weren't based on comments. So I just wanted to make sure that sort of the kind of the scope of the council's review is really everything.
Yeah.
You have the authority to review everything, even if it's not brought up by anybody else.
Thank you.
Counselor Byer.
On this particular issue, the reasons exception, as we get larger solar facilities being proposed on agricultural land, I think just being mindful of our findings and know that once the council issues a certificate with certain conditions, accepts certain evidence, that kind of becomes the touchstone for other developers. So I know I get hung up on precedent, but it's a thing. And just trying to make sure that how we articulate our findings and what kind of evidence we rely on to make those findings will be pretty important, especially when we have no real specific guidance in our administrative rules or our standards. So it's just something that we as council have to be paying attention to, and how that information is portrayed for us just is a big deal, because I think this will become a bigger deal. Thank you.
Thank you very much. Yeah, and just for clarity, at the public hearing, I believe the applicant just reiterated what was already provided on the record in Exhibit K, like the agricultural mitigation fund and how they got there, and like the dollar amounts and where it was going, and specifically to the Morrow County grain growers and Oregon State's agricultural research program. So I thought that was like, it was a summary of what they had already provided. Well, we will continue to evaluate the conditions proposed by the applicant and their analysis provided by their third-party consultant to determine if there are any information gaps or additional conditions that should be imposed to ensure that this reason can be realized during implementation. So I guess with that and with your feedback, there may be changes to the goal 3 portion in the proposed order.
Thank you.
Yeah.
Mr.
Please.
McVeigh Walker,
Sorry.
I had if we go back to the locational dependence
Sure.
factor, and I know with the West End, there were no new transmission lines required, if I recall. But we did have an interconnection agreement that we required on that to help make the case of locational dependency being one of the 4 reasons. And so that's the same situation here. No new transmission lines really required to connect into, or is it?
Here, for the Wagon Trail facility, there would be 0.6 miles of 230 kV.
Right.
But that would then connect with the Blue Ridge, an existing Blue Ridge substation.
Yeah.
Which is in the southern, yeah. So on that map, it's right in the center. So there's that big blue rectangle. That's the battery center, but the dark blue is the Blue Ridge substation. And going laterally to the left is the approximate half-mile transmission line that's being proposed.
Okay, and so we'd kind of do the same condition of approval for an interconnection agreement? Okay, great. Thank you.
Yes. And there is an existing Umatilla electric line that runs north-south, and on this figure, it's in the middle of the figure itself, the blue line.
That bombing?
Yeah, I mean, well, yeah, that is Bombing Range Road. Yes. Yeah, correct. Okay. I think we can go back to the standards portion unless there's other questions, comments, instruction for land use in goal 3. Okay.
Mr.
All
Chairman,
good.
can I get a clarification?
Yeah, Counselor Devlin.
in terms of that we may be addressing more in the draft order, now all we're doing today is a review. And how does that mean we would review the adequacy of the justification that we have in the draft order for the goal 3 exception based on the Morrow County concern, and obviously taking into consideration the applicant's response? The reason I'm asking is because that would imply that there's perhaps some, perhaps not significant, but some change to the draft order. So in the next committee, would we be making a decision to approve or not approve the draft order, or would we be reviewing it again?
Yeah, so for the record,
Secretary
Cornett,
Cornett.
Councilmember Devlin, and really just everybody kind of as a sort of a procedural point, can you go back to the procedural slide? Yeah, that one. So where we're at now is the draft proposed order. So I always like to say it in this way is this is staff's document. It is staff's first recommendation. We've evaluated the application and made our findings of fact, conclusions of law, conditions of approval based on the information that's in the record, the complete application. That allowed for then a review by the public and the applicant, and the ability to comment on the record. Public's commented, the applicant commented and responded. Council commented at the last council meeting. You know, and this stage is, this is your review in terms of, okay, you've looked at the draft proposed order, you've listened or read the comments. Basically, this is your opportunity to tell us, do you think we got it right? Or do you think there's more changes that need to be made? And that's your ability, you know, through this conversation, either today, or if you want to extend it out into another council meeting, of do you think we should look at things a little bit differently? Should we look at our findings? Should we look at our conditions? And based on what we hear from you, and also looking at all the comments that we've received on the record, then we'll issue the proposed order. So again, that is still staff's document. That is staff's second recommendation of whether or not we believe the applicant has met their burden of proof and meets all the standards or not. And then it goes into an automatic contested case if there are any party or any persons who commented and, you know, request to participate. The hearing officer will determine, you know, whether they have met the burden to participate or not. They will hold a contested case hearing. And then ultimately it's that final order. So the reason why is, you know, council can make changes at the final order stage. But the reason why we want to go through this, you know, very carefully with you is ultimately it's your decision, but not now, it's later. But we don't want to sort of just push through and then have a final order in front of you. And then later on, you're like, well, we don't agree with that. You know, we thought you should have made all these different changes. That's why we're seeking your input, you know, today on this to see, you know, where you either believe things are fine or things need to be amended. So that's, again, why I want to make sure that you have enough time based upon either the issues that have been raised or your own review of the draft proposed order, whether you believe we've got it right, or based upon your review and your review of the comments, the changes that need to be made. So I don't know, Councilmember Devlin, does that help?
Yes, it does.
Okay.
And I think, but one clarification in that sense, there may be other issues that come up, but it appears their primary issue of discussion right now is the goal 3 exception, and whether or not there is more consideration that should be taken of the Morrow County comments, or just in an independent fashion, whether the commission or council is satisfied with the justifications for the goal 3 exception. So when the staff goes back and reviews that, which appears to be the direction they may be receiving from the council in the next stage of this, obviously we'll have a chance to review any modifications that are made to the order based on that review. And at that time, they could probably either ask for more time or make a decision that, you know, what is being provided is adequate, or in the council's view, it's inadequate. You know, I feel a little bit of, there's been some previous discussion in the council about goal 3 exceptions. And even though precedent is not as big a factor as might be in some areas, I feel like a kind of a necessity to hopefully get it right this time. So I guess what I'm basically saying is you'll go back, you'll review what's been the order itself based on all the council comments, but there has been a lot of concern expressed, or at least issues expressed around goal 3. We'll get a chance to review that when it comes back. We can either accept that, delay it, or reject it at that time as an adequate justification. Would
Yeah,
that
but
be fair?
So I just want to make sure I'm clear, or I'm totally understanding what you're saying. Your ability to review this again won't be until the final order.
Right.
So while we have this open right now, while the council is reviewing the draft proposed order, you can conclude that today. You can say, we still want to have a little more time to think about it, and we'll put it on the next council agenda. But you need to be comfortable with your review of the draft proposed order. And then specifically, you know, I agree, this seems to be the most significant issue. So you have to be comfortable whether you've had enough time to review, think about it, you know, see what's currently written, you know, what staff's recommendation is in the draft proposed order, whether you agree with that, or based upon the comments and your own analysis, you think some changes need to be made. So that's why I want to make sure, you know, we can take the time to kind of go over that further right now. Chase can continue to the end of this. We can loop back around to that at the end of this agenda item today, or again, based upon, you know, some solid but preliminary conversation, we can put this on another council agenda and not conclude the council's review, and then focus on that more specifically at a future council meeting. So that's entirely up to the council, what you want to do with that. But it is important that it's this time frame, council's review of the draft proposed order. You don't get another opportunity really until the final order to at least make a conclusion on this.
Yeah, and if Patrick Rodeo, I'll just add to that. Were you to make a change at the final order, that's a material change compared to the proposed order, then we have to have a material change hearing.
Yeah.
So the ideal time to get your input is really now, or if you need more time at the next meeting. While that might, you know, push us back until the next meeting, I suspect that might in the long run be more of a time saver than potentially having to get a lot of input from you after the proposed order at the final order stage. That could delay things further.
Thank you. Mr. Chairman,
Yes, Councilor Devlin.
I found myself coming into this meeting having reviewed the staff report and the comments and the draft order and feeling relatively comfortable. However, in the last 20 minutes, as people have been talking, been going back, reading the Morrow County comments, reading the applicant's response, reading this applicable staff area, and I don't feel as comfortable as when I was coming into the meeting. It's not that I'm saying that I'm not okay. It's simply that I don't have the degree of certainty that I had before. Because I know the applicant's response came in on June 11th, which wasn't very long ago. And I know that members received some of this just Wednesday. So I do think, in a sense, if we're going to continue to discuss this, it might be better to resolve this issue by delaying the council's consideration to a future meeting. It might make our July meeting more probable, but that's fine.
Thank you, Councilor Devlin. Councilor Imes?
Thank you, Chair Howe. I said earlier, I had some concern, and I still feel that way, especially after actually getting a chance to look at some of the comments this morning. And I would also feel a whole lot more comfortable if I had a little more time. Thank you.
Councilor Byer?
Just a quick comment. It seems as if out of all the comments that we received, and there really weren't that many comments, the goal 3 exception comment is probably at the heart of what we're still struggling with. And if we could just focus our efforts on that section of your final staff report, and if you can help direct us to the applicant's evidence as to that section, that would be helpful, and I think we could have a more productive discussion that way. I'm comfortable with the other comments and how you've responded to them, but this one seems to be a little trickier. Thank you.
Councilor Imes?
Chair Howe, I did have a comment because I did get to look at what was presented last week. And I just wanted to make mention of that the analysis was done by the same company, Eco Northwest. And so I know we're talking a lot about looking at other projects that aren't up to the same in the process that we're at now, but yet we're seeing that the same companies are doing the analysis work, but also presenting us different results, which I just have to make mention of. I mean, I think it's important. We talked about it with the wildfire standard, trying to get to a more of a cohesive approach, or, a baseline approach at least, with wildfire plans and weed mitigation plans. And now here we are looking at, a goal 3, which is a really big mitigation plan. So, and something very new for this council. So just wanted to make mention of my, that caught my eye. Thank you.
Mr. Chairman,
Councilor Devlin?
hate to take more time, but can I get a clarification from legal counsel on an issue? The goal 3 exception is in essence being made by the council. So that's reviewable. Does Morrow County have to go through a goal 3 exception process also?
Meaning if the application was before Morrow County, is that?
Well, if it was before Morrow, I think in our process, from what I've been told before, we have the authority in this area to, grant the goal 3 exception, subject to review, of course. But if we grant it, Morrow County doesn't have to go through the same process, right? It's my understanding. It's part of the site.
If the application were before the county, would the county have to grant a goal 3 exception? That's the question, Councilor.
Yeah.
I believe that is that they would, but I'm going to defer to Secretary Cornett, given his experience with local land use issues.
Yeah, thanks, Councilmember Devlin. For the record, Todd Cornett. So in this particular application, an applicant can either choose to go through in an FSEC project, FSEC jurisdictional project. The applicant can either choose local land use review or council land use review. In this instance, they chose council land use review, which means the entirety of the land use gets reviewed by council, including the goal exception process. So in this project, for this, for this particular element, the goal exception is entirely within your review. The county certainly can comment, and they have, but they do not have the authority. If the applicant had chosen the local government to review the land use, the goal exception would be within their authority.
Okay.
And if the project was not FSEC jurisdictional, but was of something in the range of this size, but not FSEC jurisdictional, it would also require a goal exception. So you have the 12, 20 acre threshold for goal exception. If it removes 12 acres of high value farmland or 20 acres of arable land, it triggers a goal exception. So the county would have to go through the goal exception process if it was their jurisdiction anyway. So, I mean, the short answer is for any significant solar size project in the exclusive farm use zone, a goal exception would be required, whether that's done through the local government or through the council.
Okay. I thank you both for that clarification. I just wanted to be sure that this wasn't a dual process, that the council actually had the authority. And obviously the county would have the authority if the applicant had chosen to go that direction. So.
Right. Council
Thank
has
you.
sole jurisdiction over the goal exception on this project.
Okay.
From a process standpoint, it sounds like, and just going back to Councilmember Byers, as I understood it, you were sort of validating maybe the desire to come back and review the goal exception. I still think it would be valuable to continue with the presentation and to maybe dispense with the other comments and issues. And then at the end of this, you can let us know, if that's still what you want us to do, is to come back, with the goal exception at a future council meeting, which we can do. And whether that's the sole focus or whether there are any other elements that you would like us to review as well. But I think probably the other ones are probably fine, but we can also analyze those. But I would say recommend that we continue with Chase's presentation and then loop back around, and then you give us your clear direction as to what you would like us to do.
Yeah. Okay.
Thank you.
Cheers, Chase.
For the record, Chase McVeigh Walker, and the last remaining 5 standards that I'm going to review, go through, actually didn't have issues related to comments on them. So they were just ones that I thought were unique or interesting. So next slide, please. For the retirement and financial assurance standard, council must find that a site can be restored to a useful non-hazardous condition following permanent cessation of construction or operation of the facility, and that the applicant has a reasonable likelihood of obtaining a bond or letter of credit satisfactory to the council in an amount adequate to restore the site to a useful non-hazardous condition. And in their application, the applicant estimates that the proposed facility's useful life to be 50 years in their application. And the applicant provided evidence in the form of a letter from an FSEC evaluated and pre-approved financial institution, specifically Wells Fargo Bank, to support their ability to receive an adequate bond or letter of credit. The letter from Wells Fargo Bank indicates that NextEra Energy Capital Holdings Incorporated has a revolving credit and letter of credit in the aggregate amount of just under $4.3 billion, which is greater than what the department recommended council find to be the total adjusted cost estimate, including ODO contingencies and applicant contingencies for this facility, which would be $30,320,583. And that total amount, which is bold on that and the third bullet, is what the department recommended council find to be a reasonable estimate to restore the site to a useful non-hazardous condition. Next slide, please. For the Fish and Wildlife Habitat Standard, this requires council to find that the design, construction, and operation of the facility is consistent with the Oregon Department of Fish and Wildlife's habitat mitigation goals and standards. And at this proposed facility at Wagon Trail, the facility would permanently disturb approximately 7 acres of Category 3 habitat. specifically native perennial grassland, and 3,667.9 acres of category 6 dryland wheat and other developed habitat. So the vast majority is disturbance to Cat 6 habitat. Only 7 acres would be to Cat 3. There would be 7.1, approximately 7.1 acres of temporary habitat impacts, and those temporary habitat impacts would be to categories 2, 3, 4, and 5, with the majority 6.5 of the 7.1 being to Cat 3. And as a result, let's see, actually, if you want to go to the next slide, please, Amrit. This is a figure that's representative of the habitat types, and you can see it's mostly all the dryland wheat, which is that orange color. And then the very next slide too is the habitat category within the analysis area. Next slide, please. And the orange is Cat 6. And you can see within the analysis area, there is other habitat categories, but very little actual variation within the site boundary that would be impacted. Just 7 acres of Cat 3 of permanent disturbance. And permanent habitat impacts would be mitigated through off-site mitigation, and that identification and approval of a habitat mitigation area, and the implementation of enhancement actions at said habitat mitigation area would be finalized in a habitat mitigation plan. Okay, next slide, please. For threatened and endangered species, the applicant evaluated compliance with Council's threatened and endangered species through desktop and field surveys in consultation with ODFW and the Oregon Department of Agriculture. And based on these surveys, they determined that there's suitable habitat for 6 state threatened, endangered, and candidate species, 1 mammal, and 5 plants. With that, there were only 2 that were known to occur within the analysis area, the Washington ground squirrel and Lawrence's milk vetch. In the DPO, the department recommends conditions that would require pre-construction surveying, flagging, and measures to ensure avoidance of these species. Next slide, please. For the wildfire prevention and risk mitigation standard, this requires council to find that the applicant has adequately characterized wildfire risk associated with the facility. It would be operated in compliance with a council approved wildfire mitigation plan. The applicant's evaluation found that the baseline wildfire risk within the site boundary is primarily low, but has areas of high risk. And in the DPO, the department recommends council find that the wildfire risk within the analysis area to be low, except for areas along agricultural and residential areas, and transmission line and transportation corridors where the wildfire risk would be moderate. And in the DPO, the department recommends conditions that would require the drafting, finalization, and implementation of both a construction wildfire mitigation plan and an operational wildfire mitigation plan.
Councilor Hines?
Thank you. Chase, does this mean that that it would be required pre-construction? That those 2 plans would be required before?
Well, there would be the construction wildfire mitigation plan would need to be finalized prior to construction, and the operational would be prior to operation.
I just know that um, this same company was just awarded at Wheat Ridge East, and there were some updates to that wildfire mitigation conditions and whatnot, and just wondered if those match up to
They-
this one.
They do,
Okay.
yeah, yes.
And then this also brought up another thought. Has the department looked further into having ODF come and bring a presentation to the council? And also, I believe they are working on a newer data report. And so as far as, fire risk throughout the state. So just wondered if there's any follow-up on that. Thank you.
Secretary Cornett?
For the record, Todd Cornett. Thank you, Councilmember Imes. We are in the process of looking to determine when's the best time to do an agenda item. We have it kind of on the list. Exactly what the month is, we're not sure yet, and what that will constitute. But the basic idea is sort of an evaluation of the wildfire standard, what's going on currently, out there, in the world with, the Public Utility Commission, the Oregon Department of Forestry, others. And so we don't have anything definitive yet. It's definitely on our list. We've been talking about it, but don't have anything exactly planned yet, but we will.
Do you guys have you heard anything about where they're at in their, as far as their new data and their new report that they're working on? Have you heard any information on that? Because I looked on the website and I couldn't find.
Yeah, we've been talking about it. I'm not sure, to be honest.
Okay.
So I don't know exactly what's going on. This is a fairly dynamic area right now. Obviously there's been increased wildfires, some related to transmission, the Public Utility Commission, the utilities, the, Department of Forestry, and not just Oregon, all over, the western states as well. So there's a lot going on with this, and, we'll try to get our hands around it as much as we can when we bring that up to, council with that agenda item in the near future, but it will be in the near future.
Okay. Thank you.
Okay, next slide, please. Nancy. Or Amrit, next slide, please. Okay, and this is my last standard to go through, and this is the noise control regulations for DEQ's noise control regulations and noise standard. And in the DPO, well, the operational noise from the proposed facility was evaluated to the maximum allowable noise limits. Construction noise is construction noise, what's the word, is construction is well, operational noise was what was evaluated, and the noise sources used in the noise modeling evaluation during operations were the battery storage heating, ventilating, and air conditioning units, the electrical components, step-up transformers, main power transformer at the collector substation, and the transmission line. In their evaluation, the applicant identified 33 noise-sensitive receptors. The applicant's noise modeling results showed that the proposed facility operation would exceed the maximum allowable standard at 7 noise-sensitive receptors at nighttime and at 4 noise-sensitive receptors within the analysis area. And so in the DPO, the department recommends that council find that the facility as proposed would not comply with the requirements with the DEQ noise regulations without additional mitigation. And as such, the department recommended a condition that, or conditions that would require the applicant to provide the department with information that identifies a final design location to be built, be it in phases or all at once, as well as the maximum sound power level for the facility components, and the results of the noise analysis of the final facility design performed in a manner consistent with the requirements of OAR 340-35-0035, which is the DEQ regulations. And this analysis, this additional analysis that would be conditioned in, would have to show that they would be meeting the ambient noise degradation standard and would not be exceeding the maximum allowable noise standard. So although their modeling results showed that they wouldn't meet it, we're conditioning that they have to meet it prior to construction.
Counselor Byer?
So this is something that we as the council would delegate to the department to ensure that this standard is ultimately met, even if we make a finding that as proposed, it's not met. I'm a little queasy about that, but I think there's a workaround. I'm just not sure what it is. So thank you.
Okay. Well, I believe that's it with my presentation. If there's additional guidance on what you'd like to do going forward, and if there's additional standards you'd like reviewed, or I mean, I'm all ears.
This is Kent. I've got one question that I should have brought up before we jumped to wildfire. And it was regarding the Goal 5 area. And just wanted to make sure that there's not any historic, cultural, recreational, or wetlands or waters of the state that fall under Goal 5.
I'm not sure off the top of my head, but I can look into it and get back to you.
Yeah, I didn't see it, but I've just, you can get back to me, it'd be fine. Yeah. Counselor Byer.
So I think based on our discussion, we probably want to spend time at the next meeting looking at the Goal 3 exception and any recommendations staff has as to making those particular findings, just because we want to get that right. I think it would also, speaking for myself, be helpful to look at how the soil stabilization and weed control plans align, because I don't know if those sometimes go at cross purposes, but just to make sure we're setting clear expectations there. I mean, I am not a soil scientist or a weed person, but it just seems like we could be working across purposes and but really spending some time on the Goal 3 bit. Thank you.
Share how there's no Goal 5 resources.
Other than, I think maybe there might be Washington ground squirrel or Lawrence vetch, that kind of stuff, but that can be, we can deal with that with conditions.
Just an observation.
Chair Byer, or
As we go back to the Goal 3 exceptions, I think lining out those findings that, oh, we don't have Goal 5
Exactly.
resources at this site. We only have a predominance of Category 6 habitat. where we make that finding about other resources. It's all in the document, but lining it out in support of that goal 3 exception would be helpful.
Chair Howe.
Secretary
So
Cornett.
we definitely will focus on those elements at the next council meeting. I would also just let council members know, if there's anything else outside of this meeting, contact, either me or Chase or Sarah directly, because if there's something else that you're interested in us providing, either following, up on something that was provided today or something that wasn't talked about today, please let us know so we can prepare that as well. We'd be happy to do that.
Thank you.
And it is important. I mean, it's a cumulative effect that is the justification. It's not any given standard. It's going to be the cumulative effect as it pertains at least to the goal 3 exception. Any other comments?
Thank you.
Yeah. Thank you, Mr. McVeigh Walker.
Thank you.
So let you get, yes, Councilor Byer.
This is for the staff in general. The tables of public comments with the applicant's response and the department's response, very, very helpful. And those are it just gives us a whole big picture. So kudos to the department staff for presenting the information so clearly.
Yep. Mr. Chair.
Yes.
So, yeah, thank you for the response on that. We're always trying to figure out what's the best way to provide information. Is it too much? Is it too little? Is it too right? What the format is. So anytime you either like something or don't like something or have any thoughts or ideas on how to change it, please let us know. Ultimately, it's your decision. When we bring this information to you, we want it to be in the best possible way. So I appreciate the feedback.
Yeah. Okay. Next item, does anybody need a break yet? Or, okay, I think we're going to take a 10-minute break. So if it's, does 10 minutes sound okay? Okay, so let's come back at 22 after 10. It's 10:24 and we're starting back up again. The next item is a briefing on House Bill 3630, which directed the state energy, or does direct the state energy strategy. And we've got, I'd like to welcome Edith Bayer, Energy Policy Team Lead, and Michael Friels, the Senior Policy Analyst, and they're going to do an overview of the current status of the Oregon Energy Strategy. Welcome.
Well, thank you, Chair Howe. So good morning. We are going to talk about the energy strategy that Odo has been directed by the legislature to engage in. And Odo is going to be leading this work, but it's going to be a combined effort with other state agencies, as well as we're going to have working groups and a lot of other engagement and listening sessions with the public. So hopefully we engage a lot of communities to contribute to the energy strategy, which we're really excited about. And so it's going to be related to the FSET work quite a bit, because we're going to have a lot of land use conversations and conversations around natural resources and make some of those decisions. Or I guess the strategy itself won't make those decisions, but outline some of the future decisions the state's going to have to make around energy policy. And hopefully we can provide some recommendations to the legislature and the governor's office in that process. So we're just at the beginning of development of the energy strategy. This is a great opportunity to provide feedback and start getting engaged. So hopefully we're obviously enthusiasts about the energy strategy. So hopefully we can get you excited about it. If we're successful, maybe we'll have us come back. We can talk to you about what we've found in some of our energy modeling and some of the recommendations we have. So if we go to the next slide, our agenda. So we're going to talk about Oregon's energy landscape to kind of give a broad overview of what we're seeing and what's happening today. And we'll talk about the energy strategy and why we're doing it, and the technical analysis that will inform the strategy, engagement opportunities, and hopefully we'll leave some time at the end to have some discussion. But please don't mind stopping us along the way, because we've got a lot of interesting information in the slides. And if you have an immediate question, I don't want you to forget it. So let's dive in as we go along, and we'll work with the time we have. Okay, can we go to the next slide, please? So this is a Sankey diagram, and this is trying to show how energy flows through the state, how it's produced and imported into the state, and how it's used at the end use consumption. So it's showing the energy flow. And so all of the different energy uses we use have been converted to BTUs, or British thermal units. So we can kind of compare and contrast the different energies that Oregon uses, and basically tell Oregon's story at a really high macro level. So I would highlight the energy produced within the state, if you're looking over to the left, what's imported, and certainly the small amount up in the upper right that's exported, as well as if you look to the right, the residential consumption, industrial consumption, transportation consumption. So we have some robust goals within the state to decarbonize. And so a lot of the decisions we're going to have to make going forward are going to need, we're going to make some decisions around how we want to use some of these resources, generate electricity or to generate fuels for transportation or some of these end use consumptions. And a lot of those are going to be some challenging decisions, and some big shifts for us. So we do produce a lot of energy within the state, but there's still a lot that we import into the state. So I do want to pause because a lot of people have questions about this Sankey chart. So I want to see if you have any at this time. No? Okay.
Mr. Chairman, I
Okay.
have one question.
Councilor Devlin.
In terms of some of the resources, I'll give you a particular reference to the resource of hydropower. Is this a snapshot it is a snapshot in time just for 2020, right? In the sense that hydropower is very beneficial to the region. Obviously, there are environmental impacts, but it's one of the things that makes it possible for us to move away from fossil fuels. But at the same time, hydropower varies from year to year and can vary quite a bit in terms of the availability.
Yeah, so it certainly can vary quite a bit. So it is representative of this year. But even in that variance, I would say the proportions here are going to be comparable. Even if year to year you see that change in hydro, the proportion of kind of hydro to natural gas to petroleum, if I showed you a chart over the last 5 years, it would look very similar, because this is at such a high macro level. But you're right, we are very dependent on that hydroelectric system, and it has made for relatively inexpensive energy for Oregon in the past. Does that answer your question?
Oh, yes, it does. Yeah.
This is Kent. I have one.
Yeah.
The nuclear that's up there, that's just because we're on the grid. Is that right? Yeah. Because none's being produced here.
Yeah, so this is, so the energy that flows in, so that's from Washington. And so that goes through BPA and a lot of the community-owned utilities that get power from BPA. Some of it comes from nuclear.
Yeah. Okay.
Yeah.
Chair Howe?
Yeah. Yes.
So
Councilor Hines.
could you explain a little bit more about the biomass category?
Yeah, so
Details?
yeah, so biomass. So if we're looking at very little biomass goes into generating electricity, but you can see quite a bit goes into industrial or residential consumption. And so, yeah, so people heating their homes using biomass, using wood to heat their homes, or some industrial processes that use biomass, is whether they're recycling some end-use product or.
Mainly residential though?
Well, I mean, there's quite a bit that goes into industrial consumption. And then if you see the biomass that goes into transportation, so that would be something, if you're making biomass, making ethanol or making some kind of biofuel or something like that. Yeah, so hopefully we're capturing all those kind of end use fuels. Okay.
Thank you.
All right, well, so we'll go to the next slide, please. All right, so even at a simpler level, what are the major energy sources that we're consuming within Oregon? So you can see another level, how much it comes from petroleum fuels, natural gas, and hydroelectric power. And at those end resources, based on the different sectors, we've got how much is used by transportation, the residential sector, the industrial sector, and the commercial sector. You can see transportation is the largest amount. Next slide, please. So this is the resources we use to generate electricity, just focused on just electricity. And so this is what's generated within our state and what's generated outside of our state that's imported in. And so you can see hydropower, as we've noted, is a huge resource in the largest one, but we still use a lot of natural gas and coal to generate the electricity that we consume. So we have long-term goals around from House Bill 2021 around decarbonizing our electricity sector. And so we go to the next slide. So that's going to require changing how we use how we generate some of our electricity. And that could be with natural gas coming with decarbonized fuels, incorporating renewable natural gas or hydrogen, or it could be electrifying or using other resources to generate more electricity. But this is just an idea of kind of the scale of the change that we're talking about. Yeah. It's quite a bit of a change. Yeah. And with electricity, we're also talking about greater generation, needing more of it, as well as cleaning up the electricity that we're already using. So it's a robust challenge. Go to the next slide, please. And with transportation, this is demonstrating all the different fuels we use. We kind of mentioned some of those biofuels, ethanol, and biodiesel, but for the most part, petroleum fuels really drive the transportation fuel use within our state. You can see gasoline and diesel make up the majority of it. So we do have goals around the Clean Fuels Program and trying to decarbonize and reduce the emissions that come from transportation fuels. So if we go to the next slide, that does mean changing the way we use a lot of those fuels. And so this is, again, trying to demonstrate the big change that we would be talking about, alternatives, whether that's turning to electrifying transportation or using low emission fuels or some kind of other alternative, whether maybe a biofuel. Okay, next slide, please. And then when we're talking about buildings, this is showing what we consume within buildings. And so you can see it's dominated, as you probably recognize, by electricity, natural gas, and biomass we talked about. The majority of the fuel use we use within these buildings is critical. And so if we're talking about making some changes, there's some big changes to be had. It would have many cascading impacts if we were to electrify more of these applications or use other fuels to supply this consumption. So next slide, please. So that was kind of a macro level view of energy in Oregon. So now we're going to talk about why an energy strategy. So in the 2022 Bioenergy Report, we took a look at a variety of different studies, looking at decarbonizing energy within states. And we concluded that we've got a lot of existing programs and a lot of great work we're doing, but we need to make sure everything's directed kind of one direction. We need to figure out how we're going to do it, how we're going to meet all these policy objectives and decarbonize, and how can we get everybody aligned. And so we recommended an energy strategy because we thought it would help align policy development across a variety of different state agencies, set some expectations, certainly signal to industry and business where we're looking to go, and also take advantage of opportunities within technologies and say, okay, how can we make sure as a state we're investing effectively and coming up with a good, effective plan that efficiently uses state dollars on our future economy and our energy future. Okay, can we have the next slide, please? So, and this is the House Bill, House Bill 3630, that directed Oregon Department of Energy to lead this work. And we want to develop this energy strategy. And it's important to note that this energy strategy isn't necessarily a linear plan of how we're going to get to a certain point. It's more an evaluation of different opportunities and taking a look at, we're going to do some energy modeling. What could it look like? And what choices do we have in front of us? And what policies may inform that? So we're going on a trajectory and working together. It's also an opportunity for us to take a look at the economic and employment impacts, energy burden, affordability, and many things that we need to take into consideration with this energy transition that's upon us.
This is Kent.
Yeah, please.
Is energy burden the same as demand?
It's not actually.
It's not.
So energy burden kind of refers more to affordability. And so it takes a
Oh.
look at what are the energy costs of households and says, I'm trying to remember what the percentage is, but
Yeah.
what is the percentage that they're paying for their energy costs?
Okay.
And for many Oregonians, it's very high.
Yeah.
They have a greater burden.
Yeah.
And there's, looking at that household, there's transportation burden, so the cost of
Right.
transportation, as well as the burden for their electricity, natural gas, or their
Got
fuel
it.
bills. And it's important for us to take a look at that. One, to look at disparity, because if you look at rural Oregonians or
Right.
urban Oregonians, there are big disparities there. We look at, for transportation, larger vehicle miles traveled. For a lot of people who live in rural areas, they have to travel a lot more. They might have higher transportation costs. Are there opportunities for us to address that or take that into consideration? If we're going to make choices around the fuels that that people have access to, all of a sudden, are we making things that aren't affordable, or we're increasing the energy burden for a lot of the communities within the state? It's something that we really need to take into account when we're making some of these choices.
Thank you.
Yes, of course. Okay. Next slide, please. So the energy strategy itself, we broke up into 3 parts. So the energy strategy will have some policy objectives. And so we want to basically create kind of a summary of what we found out when we do our energy modeling, the pathways that we took a look at, the different options, and we'll talk about kind of those different scenarios in a bit. Description of how we work with stakeholders. So it's going to be critical for the success of the energy strategy that we involve a variety of different communities within Oregon, not just within the energy sector, which certainly we want to involve the utilities and people directly working in energy, but we want to work with a variety of different communities so we can have those conversations, let's say around affordability or energy burden, to make sure we're taking into account the changes or recommendations we make sure they take into account the impact to all these communities within Oregon. And at the end, the goal will be to provide some policy recommendations to the legislature and the governor's office on what could put us on a trajectory to meet our goals and take into account equity in our energy future and energy transition. Okay, next slide, please. So within the technical analysis, we've hired a technical contractor, SETI, and they are going to do some energy modeling for us. And so we'll kind of talk through what that looks like. I don't know about you, but I'm not as familiar with energy modeling as some, and it gets really technical. If we go to the next slide, but essentially we're going to create a baseline core scenario where we are trying to get from where we are today to meet our emissions goals in 2050. And taking a look at those emission goals, how can we be on a trajectory to get there? What kind of changes do we need to make? What do we take into consideration? So we have that core scenario, and then how can we compare it to? So what kind of things can we find out by comparing different options of, let's say, we're going to electrify a lot of transportation. Okay, well, does that happen faster or slower? And how does that change things? Do we retain fuels like natural gas within buildings long-term, or does that change? There's a lot of different trade-offs and evaluations, and that's kind of where we can kind of show the differences and opportunities within the state and kind of the economic or equity or other impacts. So, but the model can't answer all questions. And so we're not going to necessarily litigate existing policies. We're going to be taking a look at what the future could evaluate. And there's some limitations to it. So it's not going to solve all our energy problems so much as it's going to be an evaluation of kind of what the future might look like. And when you look at energy modeling, the importance of developing it is really developing it to create a trajectory. It's not to predict the future, not to predict exactly what's going to happen 20 years from now. I wouldn't trust it if it did. If anything, it's putting us on a trajectory so we can see what the next 3 to 5 years should look like to make it point us in the right direction. Okay, next slide, please. So, and it serves to inform our decision making. So, as I said, it's not going to predict the future, but it's an investigation of the different choices and options. So hopefully by doing this, we can have great conversations in our working groups and different engagement opportunities and talk about the different opportunities within the state of what should be incorporated or considered, and hopefully develop some strategies within the state of how we can invest state dollars and what policies we need to develop to set us on a good trajectory for the future. Okay, next slide, please. And so within all this, we're going to be trying to figure out some big energy questions. And so here's some kind of examples of pressing questions we have in energy. We're all naturally curious and want to know what our future is going to look like. But these are all the different things that we want to try to answer by comparing different scenarios or different pathways we might be able to go as a state. So for example, what if some technologies or new clean energy resources are delayed or not developed? Hydrogen is certainly an option. It's certainly something we want to develop as a resource. Is that quickly developed and we certainly have a immediate hydrogen supply, or is that slow to develop within the state? And what will that impact, and what would the cost of those different alternative fuels? And consumer adoption of heat pumps, electric vehicles. Certainly, I know you talk about transmission expansion. Is it easy to expand transmission and have access to the state? We certainly know there's going to be more wind development east of the Rockies. There's going to be a lot more solar development within the Southwest. Is Oregon able to tap into those, develop transmission lines so Oregon has access to it? Or if it doesn't, does it need to develop more of its energy within the state because transmission expansion is hindered? So there's a lot of options there and things to consider. Okay, and I'll turn you over to Edith.
Thanks, Michael. Yeah, next slide. So I'm going to take us a little bit into the weeds, but not too far, I promise, of the modeling. And it's so that you can understand a little bit kind of how we'll be looking at the world to come up with what's going to come out of all of this technical analysis. Because in the end, at a high level, what we're going to be doing is engaging with folks over the next few months to understand what the priority questions are that we can answer with this kind of tool. So essentially, we can pull a few levers, but we have a budget. We can't pull every lever. And so we can test out, if we have more or less transmission, what does that mean in terms of how much resource build we need in the state and outside the state to meet our goals, that kind of thing. So, but to bring you along the journey, I think it's helpful to look a little bit under the hood of what we're looking at here. So essentially the whole process, the technical analysis starts with where are we today? And so it looks at Oregon's economy across split up between residential, commercial, industrial, and transportation. And we just kind of see, how many houses do we have? How many apartments? How many, just what do we have in place today? And then we project that out over time, all the way out to 2050. So we'll be looking at a 2050 timeframe. And so, there's a trick to that. We don't know, but we're going to try to make some reasonable assumptions on what that might look like. And then that determines how much energy we need to meet that demand across the different sectors. And we're really interested in how much electricity we need, how much we need in terms of transportation fuels and direct use fuels. And that might change. What we see today in terms of that breakdown might change. For example, if we do a lot more electrification, that first diagram, I always call it the noodle diagram that Michael showed, the electricity slice might grow, for example. And certainly if we're decarbonizing, the resources will change. So we might go from natural gas to renewable natural gas for some uses, for example. And then finally, the model kind of takes all of that information, what's the demand, what's the energy need to meet that demand, and then it sets some rules and cranks out some results. So we have to maintain reliability on the system. We're testing out meeting our energy policy objectives, so that's built in. Cost is really important, so we need to make sure that we're minimizing cost wherever possible. And there is the possibility to introduce some constraints, and I mention that here specifically because we can build in some constraints that take into account our land use rules as they exist today, for example. So the model won't say you could build anything everywhere, no constraint. So we can build that in as well. If we go to the next slide, please. So what goes into a scenario? Essentially, a scenario is where we test questions, and we'll be able to do a few different scenarios in this analysis. And there's kind of two ways that we can test different questions. And one is by having more or less of something. So imagine, here are the examples, heat pump adoption. So imagine that more people adopt heat pumps. That'll have an impact on where we're getting our energy from and where we need to get it from. And we can reduce it, and that'll also change the picture. And it'll also change costs potentially. So we'll learn something by by moving that lever up or down. And then there's the option to just turn something on or off. So we could say, no new transmission is built by a certain year. What is that going to do to everything else, to what we need to build and how much we need to build in Oregon versus outside of Oregon? So this is kind of, looking a little deeper under the hood, the types of levers that we can pull in the model to come up with what the world would look like if these things were to happen. Essentially, we're testing uncertainties because there's a ton of uncertainty that we're dealing with and trying to think through how we meet our decarbonization objectives. And so this whole process is to come up with a lot of informed projections, reasonable projections, and then test things out. If we go to the next slide, and this is just to show you how we look at the economy. So we split things up, as I said, by residential, commercial, industrial, transportation. And then there are 70 subsectors. So I haven't counted these bullets. I don't think it adds up to 70. But this is just a flavor. So you can see it's kind of, we really get down to almost the appliance level in looking at these subsectors to understand what's in place today and what we can expect over time across each sector. And then if we go to the next slide, it's also really important to remember, referring again back to that noodly slide at the beginning, that we're not an island and we're really interdependent in our electricity system. We're interdependent on where we get our liquid and gaseous fuels. And so the model is going to be looking at the whole region. And will include things like accounting for competition for fuels. So there's not an infinite amount of biomass, for example. And so we'll be looking at what that competition will look like and who's looking for how much over time. So competition for biomass, for renewables, for hydrogen derived from renewables, that'll be built in. We'll be looking at the whole electricity system, the full footprint. We'll be capturing transmission lines and pipeline flows over the region and constraints on any constraints on building new transmission lines and pipelines. And I think it's important also to say that there's a benefit here to looking region-wide because we benefit from really different weather patterns and different time zones across this region. So particularly for the electricity system, when it's raining in Oregon, which I know is hard to imagine, but when it's raining up here, there might be sun in the Southwest that we can benefit from during the day to help meet our electricity demand, for example. So we also get the benefit of the regional view in thinking about how we meet our decarbonization goals. Okay, next slide, please. Okay, so I just wanted to make a few notes on how we're thinking about land use and natural resources. One is I just want to emphasize that we'll be using the ORISA tool, the Oregon Renewable Siting Assessment, to inform the work that we're doing. I think that's important to say. We'll really be digging into the challenges, both in public engagement, and we'll have a working group that's focused on land use and natural resources. And that'll be an opportunity for some experts to come together and really kind of hash out how to think about these things and how we can kind of honestly do what we can in the model, and what we can't, we can consider at least in the policy discussion that comes out. And I just included some of the things, we've heard a lot more than this actually, but some of the things we've heard so far, there's the tension between development and land conservation. There's, what do we do with industrial zoned areas when we're redeveloping them? There's a lot of discussion about urban growth boundaries for housing versus solar siting. We're paying very close attention to the Land Conservation and Development Commission's solar siting rules advisory committee and kind of the discussions and how they're unfolding there. And we've also heard a bit about agrivoltaics. So this is really just a flavor, and just to say that we're just at the start of the conversation. So we'll be talking about ways to engage shortly in this presentation. So if we go to the next slide. There are also some things, and this is really the list of things that's difficult to model in that central model, but we still want to include some technical analysis. So one thing that we'll be doing is thinking about household budgets. And so the energy wallet, the idea of this concept is really to look at the household budget across different types of energy that we pay for. They tend to be separate bills, but it's important to look at them together, particularly when you think about somebody buying an electric vehicle. That's kind of the easy example because you're not paying for gasoline, but now your electricity consumption goes up and your electric bill is going to go up, but the other bill is going down. And so we want to make sure that when we're thinking about things like Michael mentioned, energy burden, that we understand what that picture really looks like. And it won't be the same for every household. So we want to do some differentiation. And this will be one of the challenges in the working groups too, in how we develop some representative kind of customer groups. There will be too many to include everyone, but we will try to be as inclusive as possible so that we can provide some useful information for policymakers. We'll also be looking at health impacts. So there's a tool called the U.S. Environmental Protection Agency's COBRA model. It essentially looks at air quality and health and the link between the two. So we can learn about what happens to air quality and what the impact is on public health when we reduce internal combustion engine vehicles on roads or reduce biomass combustion, things like that, that would produce pollutants that this model can measure. So we'll be looking at that. And we're also considering how to consider the geographic differences and the kind of different economic and other differences across the state, if we look even by county, for example. So we haven't figured out how exactly we're going to do this. It's another area that we're going to engage with folks about. But we kind of recognize that this is really important, that we need to consider the differences across Oregon. So we'll be doing that. And we'll also be looking at things like community benefits. So kind of building on existing discussions in Oregon. It's not just about cost, it's also about the benefits that can come from some of these measures. So one example is, there are co-benefits in terms of resilience of things like weatherization, PV panels and batteries, right? So kind of thinking through those things and how they can benefit communities. And then we'll also be looking a bit at the economic and employment impacts of different pathways. If we go to the next slide. So I just want to emphasize something that Michael mentioned, which is that we're not just making things up here. We're grounding the analysis in existing policy, in existing utility integrated resource plans and clean energy plans, CPP compliance plans. We're reviewing Oregon energy policies with other agencies to make sure that we're fully aligned and that we're taking into account everything that's in place today. And we're also reviewing recent studies that have happened that provide data and information that we should be taking into account. And you saw that map of the region. So we're also reviewing regional plans like the Northwest Power and Conservation Council. They'll be kind of still in the relatively early stages of developing the next power plan, but there's a lot of work going into it. So we're in touch with them on that. And we're also going to consider the regional efforts that are happening. There's a lot happening right now on electricity markets, on resource adequacy, on transmission. So all of that, we're aware of it, we're taking it into account, and we're making sure that we're not contradicting anything that's already been decided that's in place. That we're considering that our starting point. So if we go to the next slide. So next we're going to talk a little bit about engagement opportunities. So I just wanted to pause to see if there are any questions on what we've presented so far on the kind of the modeling and the technical analysis.
Mr.
Any
Chairman?
questions? Oh, Councilor Devlin.
Yeah, thank you, Mr. Chairman. Probably somewhat more of a comment than a question. Mr. Chairman, I could spend about the next 12 hours discussing this, but I'll use just about 2 minutes. As the speaker may know, I spent 4 years on the Northwest Power and Conservation Council, which I won't go into now why it was created and what its role is in terms of long-term planning for the 4 states of Oregon, Washington, Montana, and Idaho. But just a couple of comments. One is that I would just encourage that you look as far beyond our borders as possible in terms of impacts and perhaps in terms of opportunities also, because sometimes states tend to really stop their discussions at their borders. And I know you're not talking about that, but this is an area which you really can't do that. One of the areas that wasn't discussed as a resource and at the other council, what we constantly discuss is the importance of conservation. You've briefly described that, but in a sense, our power needs in the region would be much greater if it wasn't for the significant conservation efforts that we've had over the last several decades. Much different, and we're much better off. It's one of the reasons the hydropower and the conservation that clearly makes it possible, even under what we would believe our probable scenarios are, to totally decarbonize the electric provision in the region by the years required by various states. The other thing is that I would hope you'd look at, you mentioned this briefly, but part of it is not just how many transmission facilities or resources we have, but how they're managed. And there are some significant questions about how our existing transmission resources are managed. Also, there's significant questions about how our production resources are managed. I think the other thing here is that it's a very hard area to plan out. I mean, the Northwest Power Council is a 20-year scenario focusing on 6 years. It's a very hard area to plan out, particularly given changes in technology. And the last thing I would state is that as far ahead as we are on the electricity side, that impacts 3 out of those 4 sectors directly, unfortunately, doesn't seem to impact the transportation sector that much yet. We are way behind on the decarbonization efforts in the transportation sector. The remedy to that may not be all electric, there may be other technologies, but we are so far behind that it would take an enormous effort, both on a state, region, and national level to get anywhere close to our objectives. Yeah, I was noticing here 0.3% in transportation for electricity in particular.
Thank you. Those are all excellent points, and I'll just respond to them very briefly. One is that 100% agreed on conservation, and we will be taking a very hard look at it. And I'll actually expand that and say we'll be taking a very hard look, to the extent that we can within this model, at the demand side, because those electric vehicles that might be putting a lot of strain on the system actually have batteries in them that can also provide a really big resource for integrating renewables into the power system. So I think there's a lot when we look out to a 2050 timeframe that needs to be worked out, and the demand side is a very, very important part of that. I also agree. Looking beyond borders, I know, for example, in that map that Canada isn't included, but we are considering Canada. It is part of the Western interconnection, so there's a bit of a limitation on that map that we probably just need to fix so we don't create the wrong idea.
In Texas as well.
And yeah, that's right. Yeah, that's right. There's part of Texas as well. The transmission piece and how transmission is managed and how production resources are managed, I think that some of that might be incorporated into the model, but I think a lot of that will be more in the policy recommendations discussion, and that's a very important one. It is really difficult to plan out to 2050, and we recognize that, and we'll do the best that we can, just like anybody who's doing a really long-term outlook. I'll just emphasize that this isn't a plan. It's a strategy, and so it's supposed to give us some strategic direction. And I think that in terms of policy recommendations, they're more likely to focus on the nearer term, while giving that perspective, that enriching a bit our perspective on kind of long-term trade-offs and options more than anything. Yeah, transportation, lots to do. And it's not just about electrification. There's a lot more in there.
Just a quick
Councilor Byer.
back to the regional piece, the first graphic, the noodle graphic, with the amount of coal coming into the region still, I had no clue. So, you know, and I think about energy a lot, but I forgot that there was still that much coal on the grid in the western area. On conservation, which we've been talking about since the 70s, I think, and then there was a boom in the early 2000s with the green building. It seems to me that's a win-win with both commercial and industrial, where you're actually saving the consumers money. And so that, I think, would be one of those strategies we want to figure out how to get more adoption. I know heat pumps are the new, you know, let's conserve electricity. So how do we incentivize some of those conservation measures that we know? I always put that in like air quotes because we don't know much, but that would really save money and reduce demand. So anyhow.
Yeah, thank you. And we will have a working group that we still haven't finalized. We're getting close, but the kind of the configuration of the working groups, but there will certainly be a working group where the discussion on commercial and industrial facilities will come in. And it's not just to see what they project out. It's really to also talk conservation and talk about fuels and fuel switching and the roles that different industrial facilities see there and how to think about it. So, yeah.
Thank you.
Mr. Chairman,
Councilor Devlin.
very quickly, I just wanted to clarify on the coal issue. There's very little coal left in the four-state region that I described. And what little is left, most of it is, I believe, going to be closed. Every time we tried to make an estimate of when coal plants would close during the development of the 8th plan, there were more announcements of closures, and the closures were moved up. So significant coal that's probably coming into the region is coming through the grid, not from the region. There still obviously, I think, are some operating coal plants in Montana. There's some, just to be fair, there are some non-on the grid, very small plant in Idaho, just serves an industry. But coal is literally out of the picture. There's nobody planning on keeping their plants. Almost all have been closed in the region. There's no investment being made literally anymore. It's very expensive to operate under current conditions. So we didn't really, you know, there's no plans in the region for coal. The other thing is that one of the reasons the 8th plan, I think we could have overcome this if it had been an issue, but on transportation sector and electric vehicles, the council there could not rely upon the aspirational goals of various political statements. They actually had to look at the modeling and the actual adoption rate and what its impact would be. And one of the reasons there isn't a great deal of burden on the system right now is the adoption of electric vehicles is way behind people's expectations. And that's largely because I don't think the governments have made the proper efforts to move that adoption forward. But it's much slower than what people were hoping for.
Thank you.
Any other comments from council? Okay, floor is back to you guys.
Okay, thanks. So I'm going to move along because I'm conscious of time. I'm going to jump into the engagement opportunities just to give everyone a chance to see and think about how we're kind of how we're looking to make sure that folks have a chance to engage kind of at whatever level makes sense to people. So if we go to the next slide. So I'll start off by saying that Michael mentioned that we've contracted the Clean Energy Transitions Institute, CETI, as our technical consultant, and we have just also signed a contract with Kearns and West as our facilitators. So we're just getting started, which means that all of this is much of it is under development, and there'll be more information available soon. So we have three kind of structural groupings to inform the energy strategy. One is already in place, and that's an interagency steering group. And it's really to ensure state agency coordination on everything from policy to data to stakeholders. And it kind of has a core of ODO, DLCD, ODOT, the PUC, DEQ, Business Oregon, and the governor's office, which is not to exclude other agencies. There are other agencies that are really important, like housing and forestry, who we also need to engage. But this is sort of the core who meets most regularly, and we meet about once a month. We have just opened up a process to solicit expressions of interest for our advisory group. So I'll flag that a few times. So we have an online form. It doesn't take too long to fill out. We're really hoping to have a strong core group here to discuss, advise, inform ODO, really to serve as a sounding board for us. And the idea is for this group to be composed of people with diverse perspectives from across Oregon, and also to meet roughly once a month and to kind of be where we check in and have discussions, sometimes hard discussions, about where we are with the analysis, where we are with the strategy, what we've been hearing, and also decisions that ODO is getting ready to come to kind of test those kind of where we've landed after hearing a lot of different perspectives on, what a certain scenario should be, or when we're talking about the technical analysis, or what assumptions we're going to incorporate into the analysis. And then I've mentioned a few times the working groups. That's really the place to get into the weeds. We'll have several working groups working in parallel over the summer, and they'll be covering kind of the landscape that we need to cover in the energy strategy. So we'll be looking at generation technologies, at transmission, distribution, both electric and pipeline. We'll be looking at different end use sectors, so residential, commercial, buildings, industrial facilities. We'll have a transportation focused group. So the idea is really to have these groups to work through details of what's going into the model. And again, we anticipate meetings through July and August, so you should be hearing more about these groups quite soon. If we go to the next slide, we're also consulting with tribes. So there's a formal government to government process here, and so that's kind of on its own track. And we have sent, last fall, we sent letters of interest to the tribes to kind of inform them that we're starting this process of developing an energy strategy, and to engage them. And we're following up on that shortly. And we'll also engage with tribal communities and organizations as appropriate. So I think it's important to mention this piece. And if we go to the next slide, and then we also, in addition to the kind of formal structure, we would also plan to have several different types of meetings to solicit public comments, ideas, and feedback. So the first are listening sessions, which really the spirit of them is tell us what you think. So we plan to schedule a few meetings like this, probably virtual, so to facilitate participation. Also different times, so everyone can find a time that works. And the idea really is to hear from people across Oregon, what are your priorities? What are your concerns? What are the types of things that you would like the energy strategy to tell us? What would you like to learn from the energy strategy? And so we'll have a series of listening sessions over the summer to help us really guide us on what those scenarios should be and what levers we should really test out, what floats to the top as the most important and the most informative. We might have some extra meetings, the organizational meetings here, to deepen our understanding. For example, it might make sense to get together with environmental justice groups and have just a focused conversation with them on their priorities and the things that they are most concerned with in this phase when we're thinking about the technical analysis. But we'll also have a working group that's focused on equity and environmental justice, where we'll also be able to dive into some things that go into the model or accompanying it, like those household profiles that we were talking about. So stay tuned to our website and email list for more on that. And we just had a webinar last week, and we plan to have another 1 or 2 webinars this year. We're trying to organize them around kind of critical times when we've come to a decision or there's a draft that we'd like to put out for written comment. And we think it's useful to have a webinar to describe kind of what that is, explain ourselves, and ask for feedback. So that's kind of the webinars are more us reporting back. And also listening, but I think that's the listening sessions are really to listen. The webinars are to give updates and then hear some feedback. So if we go to the next slide, I just thought, so this one's animated. So I'll start and I'll say next if, you can just kind of go through as I'm talking. So the first, I just want to give a flavor of what the summer is going to look like, because there's a lot that we have planned for this summer, and it's taken us a while to get our consultant on board, and now we're like planning to hit the ground running. So in July and August, if you click next, we plan to have several public listening sessions. We might have some of these more focused meetings, and we'll get the working groups kicked off and going. And Odo staff will be synthesizing feedback kind of throughout that period. And then around the end of August, we will actually have synthesized that feedback, and we'll take it back to the working groups. So we envision each working group having a meeting where we work through kind of the analytical perspective of what we've heard from those listening sessions and what we can do in the analysis. And then throughout this whole process, the interagency steering group and the advisory group will keep meeting once a month. Sorry, you have to turn your neck to see that. And if you click again, same thing goes for government to government engagement with tribes. We envision that just continuing throughout. And then finally, in September, we plan to have a webinar where we kind of report back on what we've heard, how stakeholder feedback has informed the technical analysis, and then kind of September through the end of the year is when the modeling will happen. And that, that's like, I think of it as like pushing a big button and then waiting a day to see the little piece of paper come out. I know that's not how it works, but that's how I see it in my head. Next slide. I'm clearly not a modeler. Any real modeler was cringing right now. So just a little bit of a description. I'm almost finished, but a little bit of a description on the advisory group. The role, as I said, is really to provide insights. It's to suggest recommendations. It's to ask questions, including hard questions. We plan to have these meetings kind of throughout the process for that reason. So we're accountable to a kind of diverse set of Oregonians to kind of where we are in our thinking, why we're doing things the way that we're doing them, and for us to take on board what we're hearing and really think about it. We're also, if you go back, I just want to say that we'll ask, this is part of the pitch, right? Advisory group, great opportunity. Members will be asked to engage with their networks to help bring robust views to those meetings. So that's part of the function that we see of this group. And again, we want a really diverse representation. There's no restrictions on who can express interest. And we're asking for expressions of interest between now and June 28th. And we envision the first meeting happening on July 23rd. So if we go to the next slide, I think it's just wrap up. Yeah, so we can share this we already shared this presentation. So you can click on these links, and we encourage you.
So we post it online. So,
great.
So the final version of the PowerPoint presentation for anybody who's listening will be posted online on the council's website.
Excellent.
They can provide all this info or find all of this information in the future.
Great. Thanks. And that's really everything. So are there any questions on the stakeholder engagement process or on anything that we've presented so far?
Councilor Beyer.
Just an observation from living in different parts of the state and working for DLCD in a former life. It may not be one strategy because we have these really significant regional differences, and investing the time and effort to be in the communities if you can. And that's something that I think the Odo staff here and being on FSEC, getting out into the communities to really listen. And I don't know your budget, so I'm not telling you how to spend your money, but it will pay off, it will build trust, right? Which is part of getting a strategy adopted. So if you can make it out into some of the farther realms of Oregon, I think it will end up with a better product. And just finally, I'm really worried about transportation, but that's just keeps me awake at night. So thank you.
Thank
Any
you.
other comments? Secretary Cornett?
Yeah, just so when this bill was kind of going through the legislature, we gave council members, updates as to, what was happening, when it was approved. So this felt like a good opportunity to provide you an update as to where it's going. We will be asking Edith and Michael back in the future as well to give an update, at least once, if not twice more, as to kind of the status. I think this has pretty significant impacts, or will have pretty significant impacts on ultimately what projects come to FSEC. So, this doesn't have direct right now, but as a strategy then kind of creates more thoughts and ideas, and plans and legislation that then will actually have very definitive impacts on what you all see. So there's a lot of relevance here, obviously. So I just appreciate the opportunity for you guys to hear this, and certainly appreciate the availability of Edith and Michael coming in person and providing you the updates.
Yeah, I was going to say, this is Kent, and thank you guys very much. It was very informative. We appreciate it. And we hope you come back to give us an update when you feel it's appropriate.
Thank you. Thanks. And I'll just add, so folks have an idea, because I know I've been focused on kind of this summer. The strategy is due November of next year, and we'll kick off the more detailed policy discussions, which I think is where a lot of those regional conversations will be particularly valuable. Early next year. I can't say exactly when, but kind of, I have in mind February timeframe. I don't know if that's right, but I very much appreciate the kind of emphasis on making sure that we hear from all corners of the state.
Lessons learned.
Yes. Thank you.
Thank you. Okay. The next item is public comment. So, Nancy, well, first of all, I'll ask, is there anyone, well, let me read this. This is an information item. This time is reserved for the public to address the council regarding any item within council jurisdiction that's not otherwise closed for comment. Items closed for comment are the Wagon Trail Solar Draft Proposed Order and the Boardman to Hemingway Amendment 2 Draft Proposed Order. We've set the amount of time for individual commenters at 7 minutes. And I have folks here in the audience. We've got Troy Jones and Irene Gilbert. So, Mr. Jones, would you like to come up? It's on.
Oh, it's on. Okay. Thank
You're,
you.
you're good to go.
Thank you, Chair Howe, council members. It's good to be back again here in Salem, be able to see you. I've attended the number of meetings since January, and I've been learning a little as we go along. It's very informative, and thank you for allowing us to have a moment to speak. I wanted to go through a couple items, just to review, kind of give an update as to where we're at. And then I have a couple observations. I will try to keep it within that 7 minutes. So first, I wanted to notify the council that we have followed your thought process, and we are pursuing change in the statute 469.504 with the legislative council. We've got it before legislative council, doing a review with them to see how everything aligns. So I wanted to thank everyone for that direction that we were provided. I also wanted to let you know that we have Friends of Gap Road has formally organized since a couple months ago when we were speaking. We're considered a nonprofit PAC at this point in time. So I just think I should go on the record to state that. I also should say, I guess this is Troy Jones for the record, 2233 5 Gap Road.
Thank you.
I apologize for missing that. A couple observations. Look, it's really, to me, it's really interesting, and it's very clear that this council understands the tension between land use, proper land use, and the need for green energy or clean energy. Where it does not go unnoticed that you all have a strong sense of the rural heart, if you will, of their values. And the things that I've noticed as we've gone along is the attention to the potential wildfire, noxious weed control, aesthetics, all that you're taking into consideration. And for that, we're very, very thankful. I think that that's very important. That tension will continue, obviously, but we do recognize, or at least I recognize that effort is being applied. And it's very important that you continue to do that. So we also see that you don't take these responsibilities lightly. And for that, I'm very appreciative. So that was about all I had for today. And I wanted to thank everybody for the time.
Thank you very much, Mr. Jones. The second one we have is Irene Gilbert.
Hi, Irene Gilbert, 2310 Adams Avenue. And I also appreciated the discussion about goal 3 from the council and your review of that and continued concern with making sure you do that right. One thing, at the last meeting, one of the presenters said, when do I get to ask questions of the council? And I've been thinking about that. And I think that's a really important issue, because really there is no communication back and forth between council members and the public. And I think it's a lost opportunity for the council when that does not occur. One thing I can tell you about my own experience during the previous, actually, Amendment 1, there was some discussion about, I made a comment about not feeling that the public had been notified of their rights to participate in some changes to site certificate conditions. And I believe in my comment, I said it was not my intent to ask for a contested case on that issue. But what I did do is send a letter to council asking for some discussion about the issue. And that letter didn't get to council before it was held up like 2 months. And so I had to make a decision about asking for a contested case on that issue. Well, so that's what I did, and I was denied a contested case. So the next step that I took was to file with the circuit court in Union County, because in spite of what the notice to me said about where I filed an appeal, I had done a lot of research into the litigation issue and where appeals go and the limits of what the Oregon Supreme Court hears in terms of FSAC issues, and found multiple cases where it said that the Oregon Supreme Court that had a narrow focus, which was about whether or not if you're challenging the approval or denial of a site certificate. So anyway, I sent that to the circuit court, And immediately, Oregon Department of Energy filed a motion saying it was the wrong jurisdiction, so I didn't get my issue heard. And I objected to that. I won that. And then immediately after that, there was an appeal to the Oregon Supreme Court on the issue of jurisdiction. And I'd like to say the issue of jurisdiction has been heard by the Court of Appeals, the Oregon Supreme Court, Marion County Court, Union County Court, and there is some court cases that go way back several years on this issue. So at any rate, the next thing was when that was denied, there was a motion from Oregon Department of Energy and the developer to say that my issue was moot because the site certificate was now final. And I argued that no, it isn't moot. There's still things that can be done to fix this. And so I just got the result of that hearing, and the request to claim that it's moot was denied. So I still have, this has been months for me to try to get a hearing on this issue of fair notice to the public and where that appeal goes and whether or not there's some resolution to it. I don't know what will happen next. I know that there is a schedule for my issue to be heard in August now, unless the developer or Oregon Department of Energy come up with another motion to do something to avoid having this case heard. But I guess what I'm leading up to here is, had the council received my letter timely, had the council had some discussion with me about, it was clear to me that council did not understand the true crux of my concern. My concern was that I wanted council to give me some assurance that when these notices go out, telling people what the scope of review is going to be, that it accurately reflect and accurately communicate to the public what it is that you're going to make decisions on and where the public has the right to participate. And what I'm saying in this appeal is that didn't happen. And that the notice that went to the public said they could only comment on addition of land added to the site certificate, when in fact, every change in a condition in that site certificate, according to the statutes and the decisions, it meant the public could comment on how those changes affected the entire facility. So rather than having a discussion with council and getting some assurance that you were going to look at those notices and make sure that the public got accurate information, now this issue of jurisdiction is being heard for like the 6th or 7th time. And I still haven't had my case heard, and it's silly because it could have been resolved with a 20-minute communication back and forth between me and the council. So that's kind of what I wanted to communicate with you, is that when you cut back on the opportunities for the public to communicate with you in terms of time frame, when there is no give and take, it's creating contested cases where they don't need to be happening. So thank you.
Thank you, Ms. Gilbert. Is there anyone else in the audience that wishes to testify or provide public comment? I don't see anybody. So Nancy, is there anybody on the webinar or phone?
There are no hands raised at this time.
And no star threes? Okay. We'll give it just a few more, 30 seconds or something. If anybody wants to provide public comment.
I see Wendy King now has her hand raised.
Okay, Ms. King?
Okay, Wendy, your mic is unmuted. You can go ahead with your comment.
Okay, thank you. I just been following this. I just have a brief comment. It has to do with the contested case that I was denied.
Ms. King, could you give us your name and address?
Certainly, my name is Wendy King. My current address is 1337 Southwest Thomas Avenue, Redmond, Oregon, 97756.
Thank you.
My public comment has to do with my denial of a contested case with the Wheat Ridge East RFA1. And I realize that final order is completed, but I want to back up and just make a mention about the procedure and about the information that was shared with the committee or the council, excuse me, and that when they were deciding about historical impacts, and it appears that there was information given that you wanted to be careful not to set a precedence. And at this time, I think it's appropriate to say that the council may need to rethink that and determine that maybe this is time to set a precedence. And I think that is the goal of these conditions or these standards, that sometimes a precedence is necessary to protect properties that are being impacted. And if you shy away from setting a condition because you may be setting a precedence, may not be the right decision. And the guidance that's given you may be unduly in favor of the developer. And I think that those site standards are in place to protect citizens. And that's all I have to say. Thank you.
Thank you, Ms. King. Is there anyone else that has their hand up or *3 on the phone that wishes to testify or provide public comment? Okay. Seeing none, then we'll close the public comment at 11:33. And I guess I should check in. It's 11:30. What does the council want to do as far as, well, we need to, do we need to get to F? We do. Want to go ahead and jump that now? Okay. So I'm going to move on to item F, which is the Sunstone Solar Project Hearing Officer appointment. Secretary Cornett will cover that one.
Thank you, Mr. Chair, members of the council. For the record, Todd Cornett, Assistant Director for Siting and Council Secretary. So if you can move to the next slide, please. So we are, this agenda item is about the potential for council to appoint a hearing officer for the Sunstone Solar Project. Just as a way of sort of starting it, every application has a mandatory contested case. Even if there are no parties to a contested case has to be held. And so for every application, the council has to appoint a hearing officer. At this point, we've not issued the draft proposed order. We don't know if anybody's interested in even requesting party status. Nonetheless, you have to appoint a hearing officer. And so that's what this agenda item is for. So you can see on the screen a brief overview of the project. And we've talked about it recently. It is a solar PV generation facility, 1,200 megawatts on 14.75 square miles of exclusive farm use on land in Morrow County. It's south of the city of Boardman. Sunstone Solar LLC is the applicant. They are a wholly owned subsidiary of Pine Gate Renewables. And where we're at now is that I gave earlier on today, I talked about that Chris and Chase and Nancy held the public information meeting on the complete application last week in Boardman, and Chris Clark, who is the lead analyst, is currently working on the draft proposed order. Next slide, please. And I brought this up at the last council meeting so you can see the location of the project. So you can see at the top where the city of Boardman is, and then the blue area with the big border is the project location. Next slide, please. And then there's just a zoomed in picture of that. Next slide, please. So essentially where we're at is, again, appointing a hearing officer. And since 2017, council has utilized administrative from the is exempt from having. Most state agencies are obligated to use them. You are exempt. However, they do have the skills, expertise, and staffing to provide the service. And so since 2017, you've elected to appoint administrative law judges for this purpose. And you can see in the last bullet the projects where that has occurred. So council has appointed hearing officers for all of those projects. Next slide, please. And so the manager for the Oregon Office of Administrative Hearings has put forward Kate Triana as the proposed hearing officer for this project. She has previously been the hearing officer for the Nolan Hills Power Project. She is Oregon Bar certified. She has done work on numerous state agencies and boards and commissions in terms of doing contested cases. She has a Juris Doctorate from Willamette University and a bachelor's degree in psychology from Colorado State University. We're very happy with her prior work on behalf of council. And so getting to the very last slide, staff's recommendation is that you do appoint her. Obviously, you have the other recommendation or the other opportunity, which is to not appoint her, in which case we would reach back out to the Oregon Office of Administrative Hearings. So with that, I will going to move to the next slide. You are at the council deliberation, and then the final slide is council decision. Nope, sorry, council deliberation.
Thank
So
you.
with that, I'll turn it back over to you, Mr. Chairman.
Thank you. Any comments or discussion?
Chair Howe?
Councilor Himes?
Thank you. I just was curious because it's the first time I've seen this on the agenda. Thank you for that background on that.
And I was pretty brief, so if you want me to go back and go over anything, we were running a little bit long on the agenda, so I tried to be very quick on this one.
Right. I was just a little confused about how when is it deemed worthy to do this? Because obviously it hasn't been done on every project. So that's where I was like, how does that work?
The timing varies. And so right when we get a preliminary application, we could do it at that point, all the way up until just at the point where we're issuing the draft proposed order. So it does happen on every application. It's just a matter of when it happens within that application timeframe. On an amendment, there is not a mandatory contested case like in an application.
Okay.
So we've been dealing with the amendments recently, which is why only if council determines that a contested case needs to be held, would we go and seek appointment of a hearing officer. But for applications, it happens every time. It's just a matter of sort of when along the sequence of that application process, we bring it before council.
Okay. Thank you.
Okay. Do we have a motion?
Mr. Chair.
Oh. Councilor Devlin?
Oh, I wasn't trying to. Anyway, Mr. Chair, I move that the council appoint administrative law judge Kate Triana from the Oregon Office of Administrative Hearings as the hearings officer for the proceedings for the Sunstone Solar Project as recommended by staff.
Thank you. Okay, do we have a second?
This is Counselor Byers, second.
Okay, we've got a motion and a second. Secretary Cornett, could you please call the roll?
Ann Byer,
Yes.
Richard Devlin,
Aye.
Marcy Grail,
Yes.
Ken Howe,
Yes.
Katie Imes.
Yes.
Motion carries, Mr. Chair.
Okay, thank you. So now. let's see,
Chair
we go
Howe?
back- Yes,
This is Marcy. Obviously, I have audio, and I just wanted to say thank you for moving the agenda item to accommodate my issue. Thank you.
you bet.
Mr. Chair, if I may.
Yes,
So it's 11:40. We have lunch now.
Yeah.
I had built in, we're running a little bit long on the agenda. I had built in within the next agenda item that you would just take a break when you're ready for lunch. You could do that now. You could wait and, initiate the next agenda item and then partway through that, stop it. It's really whatever your choice is.
it's now a good time. I think probably now's a good time, so we'll go ahead and, yeah. Sir Devlin?
Yes, Mr. Chair, that would be fine. I don't know what other people need, but 15 minutes would be adequate for me. For a break for lunch.
Yeah. We'll take 15 to grab the lunches and then we'll start back in lunch with the Boardman to Hemingway request for amendment. So 15 minutes, that'll be. Okay. I'm gonna call us back into order here. It's noon. And the next item is the Boardman to Hemingway request for Amendment 2, council review of the draft proposed order. It's an information item, and Kellen Tardyweather, senior siting analyst, will walk us through this.
All right, and this is on. Okay, good afternoon now on the dot. For the record, Kellen Tardyweather, Senior Siting Analyst, Oregon Department of Energy. I am going to be presenting council's review of the draft proposed order, comments received on the DPO, and responses, the certificate holder responses to those comments. The certificate holder is Idaho Power. Representatives from Idaho Power are here in the room, as well as their some of their legal assistance. And then I also want to thank Irene Gilbert for heading over the mountain and traveling to come to our meeting today. We always appreciate attendance. And to the other member of the public, Miss Small Tardyweather over there, I'm glad that she's here. And thank you, everybody, for anything that will unfold. So, opening remarks. Our job is hard. Right? Here at Odo in the siting division, we do some really hard work. Your job is hard, council, and you have to process a lot of information for a lot of different facilities, and it's all very hard. And I know that for each council meeting, we have specific agendas. When you make decisions, it's on a specific project or a specific topic. However, it's really important to understand that nothing that we do is done in a vacuum. Everything, the value in the work in the siting division is connecting the dots in between projects, decisions, rulemaking, understanding, when we do the same thing for a project, why, when we do something different and why. So I'm giving these remarks because I'm going to, through my presentation today, I'm going to be trying to connect the dots with different aspects of this project, but elsewhere as well. And I think that at the May 30 in-person hearing on the DPO, and then your council meeting on the 31st, those were big meetings. There was a lot of information that was heavy, but it was really cool because the next day we're undergoing your contested case rulemaking. So I want to just keep that rulemaking in mind, keep the, you know, when we talk about thresholds and rules, just like we're connecting the dots and applying them. You know, I'm going to talk about them for this project, but we're going to try to think holistically about the work that we do in the siting division. Because I am going to be like referencing and talking about some other projects. So, now let's go. All right, so this is our chevron slide. We see this for all of our projects. It's just to give you a general sense. You just listened to the Chase McVeigh Walker's council review of the DPO for an application for site certificate. You can see that we're pretty much same process steps for an amendment. One of the primary differences in between an application and amendment is an application has an automatic contested case, and for amendments, a type A amendment, there's an opportunity to request a contested case, and that comes later. What are we talking about? We're talking about a transmission line, about approximately 300 miles, 500 kV transmission line, about 273 miles in Oregon, and that's you know, it's an interesting metric there because we keep on adding in alternatives, which is what we're talking about today. However, you know, it's around 275 miles, depending on the final design of the facility. And the transmission line also includes related or supporting facilities. The vast majority of what we talk about with those are roads. There's a lot of roads associated with this project. Now, and that was in the application for site certificate, and then in the request for amendment 1, and I know this doesn't have a lot of detail in it, but so the map on our left, those are the alternatives that were approved in the application. And then request for amendment 1, there were 4 minor route changes along the line that were proposed as alternatives. So these are basically the approved facility includes kind of your one main approved route, and then a myriad of all of these alternatives, basically so that upon final design, Idaho Power can select which route they're going to choose, which I forgot in my opening remarks. At the end of this, you know, I have the council deliberation slide at the end of this presentation, but this is intended to be an interactive presentation. So because we got so many comments covering a lot of topics, just stop me if you have a question and let's just answer it. I can also, I am, and for anybody watching online or listening on the telephone, I'm running the presentation from my computer, but, and what I usually do during a presentation is I'll leave the PowerPoint and we can pull up the DPO, the site certificate, maps, we can look at stuff. So I want to make that clear. So if you have questions, you want to clarify anything, just stop me and we will go there. So this is our procedural history. A couple notes on that. At the hearing on the DPO, there was a request to extend the comment deadline because it wasn't evident we would be limiting the time in our notice. So, and again, we always are trying to improve and be responsive. So we're now in our notices for council meeting agendas. We're going to provide a, you know, stipulation if there's going to be hearings that they may, depending on how many people show up, there may be time limited, so that's evident to people. So we did do a minor extension for that reason. And then the certificate holder had until June 3rd, and then they requested a couple more days. And so their deadline to respond was on June 5th. Okay, what is RFA2? RFA2 is kind of a big amendment, isn't it? Kind of got a lot going on there. However, a lot of it is actually just kind of very similar to RFA 1 in that the biggest part that we staff really look at are these additional route changes that they're adding in? Because the question is do any of those, are we impacting new resources? Do we need to change conditions? Is there any, do these routes, do all of them meet the standard because this is a new route in a new location? And that is really what we hone in and look at. However, as we know, Idaho Power is also requesting to expand the site boundary. We're going to talk about that more. We talked about it, we've talked about it quite a bit. We talked about it and I set you up in advance of the hearing, but we'll talk about it again. So expanding the site boundary and then adding new micrositing area alternatives within that area. Idaho Power is also proposing to add in a midline capacitor station in Union County, or increasing the width of temporary construction roads, and then amending language of site certificate conditions. So, okay. I'm kind of a dork. I love the scope of council's review. This is cool. This is cool because I like anything that helps set us up to what is the question that you're asking. Well, asking and answering. So to me, it's like when we make it clear like that, to me, it makes it clear. What's the question? Here's the answer. I'm going to come back to council's scope of review. And it's designated under OAR 345-270375. So one, because we're adding area to the site boundary, which is, it's that expanded site boundary, and then those micrositing areas, we're asking ourselves, do those micrositing areas and expanded site boundary, meet the council standards? And we'll get into the nuances in between what we require to demonstrate those two areas later. And what this means is the standards applicable to an original site certificate. That doesn't mean that we're opening up the whole original site certificate and looking at that previously approved facility. That just means that, like, what are the rules on the books right now? And those rules apply to those new areas that we're adding. Number two, we're gonna check in and see if the bond or letter of credit, if that amount is adequate. We still feel comfortable with that. And then three, we're asking ourselves, and an example of this is like with the midline capacitor station. This is kind of a new, it's a different thing not looked at before. And so what we ask ourselves is, the facility with that change, like with the midline capacitor, does it comply, does it still comply with all of the standards and laws? Okay. So here's a list of folks, either in writing or in person or over the phone, commented on our RFA2 DPO. Thank you everybody for coming out. It was awesome. We got a lot of comments, and it jazzes us up because we want people to participate. So I want to make it clear that I sent council, in advance of the May 30th hearing, I sent you the comments that we had received, and then we kind of got a last minute, lots of them came in, and I sent them to you in advance of the hearing, not intending that you would be able to read or process them, but just to ensure like you have them. So if you could pull them up when somebody was providing testimony, you could do that. And then council also received the rest of the comments after the hearing, and then council was provided all of those, and then when we issued our staff report for this meeting, we also provided all of the comments again, all bundled together with a table of contents, and then the certificate holders' responses. So on the certificate holders' responses, it was a lot, right? There was a lot of pages there. And I know that it's kind of overwhelming processing that amount of information. On our end, I don't want to say that we're kind of used to it, but we do have like this filtering process. So the certificate holder, as council's aware, provided their responses by commenter, and then also grouped commenters, that's like by topic. And then Ms. Irene Gilbert also provided a document of specific comments associated with site certificate conditions, and they responded to each one of those. So what we did in the staff report is we lifted the certificate holders' responses by commenter, and then we added a column and kind of provided our, evaluation there. And everything is to kind of set us up for today. I want to make it clear that that's no decision. That's not a recommendation. It's kind of like, and what we're talking about today. This is like, this is what we've looked at so far. This is kind of where, this is our initial response, but we're going to continue evaluating these into the proposed order, and that'll be reflected in the proposed order, which is the next step. And I'll talk about that more here in a little bit. So, man, there was a lot that was covered. Up here, these are kind of small. I'm not going to talk about it. I know it's small. I'm not going to talk about, this is just kind of a summary slide of what were our topics. And we really kind of, we hit them all, like there was a lot of issues raised. Now, in our staff report to you, council, and I also for the folks, listening from the public and particularly people who commented on the DPO, I really recommend, I want folks to read the staff report, because then you see specific to like each comment, what certificate holder and our responses are. But we also kind of drafted, it was like 6 big groupings of like responses to groupings of issues. Because these comments were like, there was a lot of them, but they were really blending. A lot of them were blending what was previously approved with something that is specific to RFA 2. And so, and so what we're trying to do, and kind of that's what I'm going to talk about in my presentation today, is kind of responding to these kind of by topics, by like this kind of like big overarching response. So I'm not going to talk about everything on here. We do say kind of where we're leaning or recommendations in the staff report. And again, on the B2H department webpage, I have a link to the staff report. So the staff report's kind of an important document to process. So, but if council has specific questions about any of these that I don't cover, we can talk about them. It's also, we might kind of like bumble along a little bit because you might have a question about a certain topic, and it's going to be, chances are it's half related to kind of 3 different things, which is, we're kind of used to it with this project because a lot of issues kind of cross standards or blend topics. So we do our best to kind of like put things away in buckets, not to be dismissive, but because under council's process is we associate things with standards. So that's what our process of processing the comments is trying to, if it's not completely evident where a comment should live, or be, what standard it's associated with, we try to do that. So in preparation of the proposed order, which we're kind of in that space right now, under OAR 345-015-230 sub 2, it's what we call agency consultation. In preparation of the proposed order, we coordinate with agencies. And so this is a list of folks that we are working with. We got a comment from Union County and from DSL, Department of State Lands, and then we're still working, and we got kind of a comment. We're still working with Department of Ag and ODF&W, which is kind of like clarifying some points or getting some feedback from them. So we will continue to do that. Yes. Councilmember Imes.
ODOT was in there too. ODOT provided a comment. Okay.
They provided a comment.
So there'll be some interagency
Maybe
communication.
well, We can talk about it. We can talk about it today. I mean, I don't actually have a slide in the slide deck, so we could talk about it now since we have the reviewing agency slides up. It's a little bit, like these are, we did get a comment from Union County. No, I'm not on the DPO. But so, agencies provide comments on the DPO sometimes. And sometimes it's just in response to a notice, and then sometimes there's like substance, sometimes it's in support. We get a wide array of them. ODOT is a reviewing agency for this project. It's interesting, just to clarify, in our rules of like mandatory reviewing agencies, ODOT is not there. But long ago, ODOT got assigned a reviewing agency for this project. But that doesn't, I don't know if I don't want to say it doesn't matter, but we got this letter from ODOT about these rock quarries. Now, this is a little bit, it gets complicated. And for very much of what we're going to talk about, we do that thing like in Wayne's World where you go, we like go back in time, right? So this, and Idaho Power, as in their response, they've been working directly with ODOT. And ODOT also raised some issues back in 2017 to 2019 about potential impacts of the transmission line on these rock quarries. And we worked a lot with Idaho Power and ODOT. And, basically it's out, they kind of agreed, we're going to deal with this over here. We're not going to deal with it as part of our process. And so Idaho Power and ODOT have been working together. And actually one of those route changes that we saw over in RFA 1 was in response to moving the transmission line, in response to the ODOT rock quarry. Now, and so I would say, process wise, I'd say these rock quarries generally have been out of our process. If they were to be in the process, and Secretary Cornett knows, he knows the most about this, but it's to basically be protected as a resource in council's process, they would have to be identified in the county's comp plan as a Goal 5 resource. And ODOT and the counties have not done this. So it becomes this, so we would really have to look at other ways of where and how this resource would be protected. Do you have any more addition?
For the record, Todd Cornett. Yeah, I mean, Kellen's correct. So, kind of pulling back with any comments, we have to say first, with an amendment, is this associated with the amendment? Or is it just associated with the project, but not triggered by the amendment? So that's the first filter, because we can't review anything that's not associated with the proposed amendment. That's out of sort of the scope of a review. So we'll look at the comments by ODOT and determine, are any of the rock pits or quarries that they're talking about within the scope of the changes proposed in Amendment 2? If not, we don't really have anything to say. Then the next filter would be, are they on, private land? Are they on state land? Are they on BLM land? What's our authority? And then, ultimately exactly what Kellen said is, if they're crossing, some identified rock quarry, what can we do with that? If that's triggered by Amendment 2, what's the status of that rock quarry? And this, we could spend an entire day talking about the goals and rules related to rock quarries and the protections. It's quite complicated. But, and so the question is, we're not sure, how relevant these comments are to RFA 2 as of yet. So we're going to dig into that. So does it require some kind of consultation? We're not sure yet. I think with the agencies, that are on the slide here, we definitely know that yes, those ones, the comments, and issues have triggered some need to consult with them. With ODOT, we're not sure yet. We'll have to look into that.
Yeah, and we, yeah.
Just a follow-up question, not specific to the ODOT comments, but when we get comments from the public about a resource, say Fish and Wildlife, do you automatically consult with Fish and Wildlife on that comment if it hasn't been addressed previously? Is that how the process works?
Well, it's an excellent question, Councilmember Byer. It depends. It depends. One, and again, this is one of those things where we're connecting the dots, was the issue raised in a way that where we go, oh, that's interesting, or, oh, you raise a good point. I'm going to go into the record, or where you pointed, or you provided evidence that made us go, "Ooh, yeah, oh yeah, we should look into that." Like there's some sort of fact to check, right? And so, right, so how was that issue raised? Do we understand it? Is there something to check? And so it's kind of like one, that's filter one. Two, particularly with this record, a lot of the answers are there. You just kind of got to find it. You know, three, the answer is already addressed in one of your conditions or your mitigation plans. Like if somebody's saying, the mitigation ratio, or no, it's this many acres of cat 2 or 3, you know, like, well, it's all going to be dealt with in your habitat mitigation plan. So, you know, so that is a potential another answer. So really, when we reach out to our agencies, it's when we're like, you know, like either we don't have the answer, or we have kind of partial answer, or we just like, we have the answer, but do you agree? So it depends. So, and we'll kind of talk about what the questions we're asking these folks in a little bit. And good, excellent questions. Please, yeah, go for it. Yeah.
I just want to say that you just summarized for the public why those specific comments are so important, because it allows you to respond to the comments and the applicant to respond. So
yep,
there has to be, as you said, something to really respond to. So thank you for that example.
Absolutely. And I appreciate that. And yeah, I'll say it over again. You know, it's called sufficient specificity. And what does that mean? It says present facts, you know, or raise your issue in a manner that allows us, the certificate holder and council, to respond. Right? So like we can respond to, you know, contentions and claims that the standard's not met, or this is, or, you know, oh, there's this visual impact. But it's like, what is the visual impact? How far away is it? What is the evidence? What are you giving us to measure that against? So, you know, and I think that's, and sufficient specificity, there is gray area in interpretation, but I think that a lot of issues can be raised in a manner that just like, yes, okay, cool. We know what standard you're associated with, what resource you're talking about. You gave us enough information that we can go into the record, or go to our agencies and be like, oh yeah, hey, can you verify this or validate this? And we'll get to some of those later on, that I would say that they were raised well enough that gave us an idea that we're like, let's confirm this or not. Sure, absolutely, and I appreciate that clarification. So now in our staff report, right? So this is just this is complicated because the record for this facility is massive. It is over 15 years old. And you know, like the application for site certificate in printed form was 22,000 pages, right? The final order on the application that included all of the attachments was over 10,000 pages. And this was the document, the final order, it was the proposed order, which is very similar to the final order. And that's what was litigated in the contested case. So, which I'm going to talk about that at some point in time. So a lot of the comments raised in one way or the other, or a part of it, and I'm not sure if council, in your reading of the comments, I think it's just a good exercise to ask yourself, like, what are they, what is the issue? What is this associated with? How is this associated with our RFA 2? So I just have a short list here, and I'm going to talk about these more, but the framework blasting plan, that got changed in RFA 1. It's not, nothing's being changed for RFA 2. It's not open. That said, and in Idaho Power was correct in their responses to Ms. Gilbert's comment, is that the change that we did in RFA 1 didn't walk back any of the representations in the plan. It basically just removed this reviewing agency consultation because there's no agency that has expertise in it. So I would say that it was like a minor, more administrative change, just so it doesn't, in finalizing that plan, it doesn't get wrapped around the axle on something that doesn't exist or can't happen. So, but it's not open. So, and then I had just have generally site certificate conditions, which we can talk about those a little bit more with the expanded site boundary. The expanded site boundary, a lot of blending with the previously approved facility and conditions, right? Because we did make some condition changes to capture, particularly for surveys, that we're now only requiring surveys for the micrositing area, not this huge site boundary. And, like whether or not that causes implications for the entire facility. But so it's like there's a lot of conditions that were associated. They're either not being changed, or it doesn't implicate any council's previous findings for the previously approved facility. And then Ms. Wendy King brought up visual impacts to the Century Farm. Again, I would say here with this, there was just a statement. So I don't actually know what, again, I would say there weren't facts enough raised well enough for me to understand what that issue was. If it was associated with RFA2, there's not a change with RFA2 that is impacting their farm, right? So the visual impacts, and so this, as the certificate holder, you saw in their responses, their farm was identified as a above ground historic resource in the application materials. It said that there wasn't a significant impact and there was no management recommendation. So, that is all ASC land because nothing's changing over here. But also I would say, I don't know what you're talking about. What visual impact? Could you tell me more? I don't have anything to look into to validate a claim raised in that issue. So, and so I was kind of just setting those up. So this kind of goes back to the scope of your review, which in your staff report, I just gave you the language underneath the amendment rules. Start noon. Okay, I'm doing okay. So here it's just like the general takeaway, right? So the scope of review for this amendment, it doesn't open it up to change your findings and conclusions that you made in the final order on the ASC and RFA 1. So it's like under A, right? We're adding area to the site boundary. We're saying, do those micrositing areas, do those meet the applicable rules and council standards? For the other things that we're adding, like the midline capacitor station, does adding that to the facility change, whether or not the facility with that change complies with the standard? So that's like the difference in the questions. And then we check on the bond or letter of credit. I'm going to use this as an opportunity to connect the dots, right? Because I don't have the rule language up here. It is in the staff report, but sub B in the scope of review, that's what applies to construction deadline extensions. And that's what part of what Wheat Ridge was, right? And that's what we call a general reopener. It's where we're looking at the whole facility and we're saying, did facts change? Did the law or facts change on the ground so we kind of re-look at every council standard and ask ourselves, did the law change? Did the facts change? Did the law change? Did the facts change for each one of those? And I would say that opens everything up, under the A and C of the scope of review, adding area to the site boundary or other changes. We're not opening everything back up. So that's kind of just a little comparison there. So, okay. Do we want to do it? Okay. Well, here I have, it's like this issue was litigated. Well, actually the issue of Rice Glass Hill State natural area being a council protected area, it says here it was litigated in the contested case. This issue was actually dismissed on a process step in the contested case called a motion for summary determination. So, yeah, whether or not one would say that that's technically litigated, it was dismissed. So what I'm going to do here, I'm going to leave because I don't want, particularly for our new council members, and a lot of this is for you because and I'm council member Devlin. This is pretty, you weren't here, you of the ASC or RFA 1? Okay. All right. So then we go, so you're tracking. Okay. But this is like a lot of background for new council members because this is just a lot. And I don't want any of what we're saying to be dismissive, right? Because you probably read in like our recommendation in the staff report, we're like certificate holder response sufficient, no change in the proposed order. I don't want it to seem like we're being dismissive because this project and the materials in the record and our recommendations and council's conclusions have been like heavily litigated, I would say. So I'm just going to take a moment here. Yeah. And I'm glad that there's not really a lag on here. So I have a PDF up on the screen. I don't know what council members, I don't, when you open up materials that we provide, I'm not sure if you're doing it like just using your opening up on internet or if you're downloading them on your computer and using a PDF on your computer. I'll get, this is kind of an administrative pause here. And we use Foxit. I know a lot of folks have Adobe, but we go through painstaking lengths to try to, and this is also for members of the public who, like the amount of information that we put out there, it's a lot, right? It's a lot, and then it's hard to navigate. So here, we do all of our documents with like headers. Over here, like we turn the bookmarks into headers. And so we do this in PDFs, and this, for instance, is what it looks like on mine. And then what we did, this is the combined version of all the comments. And I also put in a table of contents here that you can click. But then if you wanted to go around to each of these, then it just gives you an opportunity to quickly go and find them. So that's just kind of a little bit of, and then we do the same thing in Word, but I think you're mostly working in PDFs. So over here this is the contested case order. we're not going to read this. We're not going to, we're just kind of demonstrating, so I don't know. So you don't feel like anything's being shoved down your throat or that this has like things are being really rushed. The contested case lasted a year and 10 months. And so we're just kind of going through, Bliss is like issuing the DPO. All right. And so, and then all of the petitions for contested case went to the hearing officer. We had a pre-hearing conference where we talked about issues, and then there was her order on party status. And then we kind of went back and forth. I know that folks, and again, connect the dots here with the conversations you've been having in rulemaking, right? Like how people raise their issue is really important. It was very confusing for us with some of the information we got. We had to kind of figure out what the issue was. And so we went back and forth, I don't know, probably 3 or 4 times on trying to understand and refine what people's issues were and giving them an opportunity to clarify their issue. So then then we more pre-hearing conferences and kind of scheduling matters and, are you going to delay? Oh, there we go. Okay. Then we do some discovery. All right. Okay. We do some depositions. Then here's the summary determination phase. Are you going to go back? These are the issues that were dismissed on summary determination. And it's appropriate to dismiss something on summary determination if there's not an issue of fact or law. Patrick, is that just a super summary? Or there's not a dispute?
Yeah, motion for summary determination is if there's not, if you essentially agree on the facts and there is not a reason to proceed on the law. So if there's not a disputed fact, or there's not a fact that is significant to resolution of the issue, that's your first step. And then the judge can decide as a matter of law. So say the parties agree on the facts, or the facts they disagree on aren't significant to my ruling. I can rule now as a matter of law whether one side prevails or not. And we don't need to go to contested case on this issue. One of the things that you're focusing on, if it's in a traditional jury trial or in a contested case, why are you going? You're going there because you're trying to resolve. They're fighting about these facts. They disagree about two sets of facts. Let's have them present their evidence. Then I'll decide which set of facts I agree with, and I'll apply that to the law. But if you don't have a disagreement over the facts, or the facts you're disagreeing about aren't significant, then the judge says, I can just resolve this now as a matter of law. And that's what she did on many issues in the contested case.
Thank you. Thank you. That's awesome. All right. So I'll just quickly go through here. The point being that there was a lot of back and forth, right? Because the contested case is also an opportunity where the record opens back up, right? Because now we're litigating issues. Again, another good filtering question I think is good to ask yourself, you know, of like, what is appropriate for a contested case? It's whether or not like there really is there something that should be litigated, that there is enough to go back and forth to provide, you know, direct testimony and evidence and expert witnesses on this issue. So that is, and so this is just, and then this is our working folder, and this is of just like the noise issue. And so you know, and I know this is, can I make that bigger? Whoa, no, whatever. I don't know what I did. So this is just kind of to, you know, these are like our little working folders of everything that happened in each of these phases, right? So, and each one of these folders is full. So, and I dare to say, but what you're going to say here is you're going to be like, what an well-organized record, Kellen. Thank you. Oh, so over here, this is the record of the contested case. So, right. Okay. Whew. Okay. There you go. Okay. So back to where we were. Okay. So I get, you know, and in the staff report, I kind of am specific to, you know, I talk a little bit more like with respect to noise. So the thing is here we can, you know, if we have questions about any of these things, or where Idaho Power, or we're like, yeah, this was already litigated, yeah, we can go in and we can answer those questions and say why. Or if you think it would be helpful for us to pull some more out of the record to put into the proposed order to support or like explain, I call it storytelling a lot, like to help support how and why we got there. I try to do that already, like in our DPO, provide you citations and tell people how we arrived at this point, because it's a crumb trail of how we got here. And yeah, but if you want us to do that more for anything, we can do that. So back to Glass Hill, frankly, and what we will do here is I'm going to pull up a bigger map. All right, let me make this bigger. Okay. All right, so, all right, do you see the gray area? The gray area is the previously approved facility. And it goes right through Glass Hill State Natural Area. Because Glass Hill was not a protected area underneath your standard at the time of the decision. And that's just how it is. Not to be, I don't want to sound crass, and it's, you know, it is unfortunate, and, you know, like B2H brings this up, you know, Joel Rice and Susan Gear. This is an area that people care a lot about, that has a lot of sensitive resources. However, this is associated with the Morgan Lake alternative. And just with respect to the council's protected area standard, it wasn't a protected area. Now it is. So now it is. And now why in this map set, we clarify, you know, we have this alternative that is kind of next to the protected area, but there's nothing in the protected area for RFA2. So as far as, you know, the comments that say, hey, take that facility out of the protected area, that's going back. We can't. We're not, that's not the decision that we're doing right now. Sure, please. Yep.
Oh, this is Counselor Byer. So had the new site boundary or the micrositing area moved into the now designated Glass Hill area, different story.
Different story.
Because RFA 2 would then impact that resource.
Well, then, yep, then you're triggering, right? Then you're looking at the language of your protected area standard. There are circumstances in which a facility can cross a protected area.
Yeah.
But that wouldn't be, as far as I'm aware, a viable option in here.
What you would do in that case is look at the conditions but we don't even have to look at those conditions because the RFA 2 boundary changes, micrositing area changes do not cross that line.
Correct.
Okay. And we're going to make findings to that effect so we know why we're not looking at it. That's sort of proving a negative. So
Yeah, and we do talk about it. We talk about it in the in the DPO already, but we can go back and, you know, maybe give a, you know, citation, again, the crumb trail in the record in a footnote of like, you know, what happened, how, you know, this is, but we talk about it, and it's also associated with RFA 1 because RFA 1 was the first time that was a protected area. So we looked at it there. So, but we can, I'll double check and see if it's abundantly clear. But yeah, we can do that.
Okay. But that makes complete sense to me. So thank you.
Yeah, no, sure. Thank you for the question and clarification. So now we're over here with this expanded site boundary. Oh boy. Yeah, this is a tough one. This is a tough, because it is mostly conceptually hard and, it is, people look at the maps, right? And a lot of people looked at the maps. And I think that this is part of where one of ODOT's comments came is they see this big fat yellow line now going way out beyond where it ever went before. And it like, you know, but it's, again, that expanded site boundary is that's not what we're looking at to locate facility components. We're asking those are now within these micrositing areas. I'm going to talk a little bit more about this. So, but I'm kind of like, go back to some of my like notes and the things that I want to like conceptually how I want to like reintroduce this is that, you know, like the council's rules and statutes are written as they're written, right? And they're intended, you know, although we get contentions on all different ways, to have a level playing field and to be clear and transparent about what it is we're going to do and the standard by which we're going to do it. So, and this is intended to give developers, you know, clarity about what they need to do. It gives us and you that like where we all go to read the language of what it is, what's the question that we're answering. Then it also tells the public. It tells the public what is it that we need, what's going to happen, and what is the standard in which we're reviewing it. So that said, that there are different rules for different types of facilities. We know that the wind facilities have, you know, standard specific for wind energy facilities, like the cumulative effects. That's not there for the solar facilities, right? For a non-generating transmission line, there's a need standard that was met back in the application. That doesn't exist for generating facilities like wind and solar. So there are differences and carve-outs for some types of facilities, but also there's some rules that apply to everyone. There aren't exclusions unless it's like a designated, you know, something that's a designated exclusion. So council's definitions and the ability to apply rules that are available to everybody else also applies to this project. And rightfully so. There's not a reason because it's a transmission line or because it's controversial that we wouldn't be applying, you know, the ability to apply the rules is the same. So these are in the rules. So I have in Stop B2H's comment letter, they asked for examples of these facilities where council's done this before. It's already in the DPO. So it's for the Bake Oven facility and Nolan Hills Wind. I chose those because they're recent. However, we have lots of other examples. Also for Wheat Ridge Amendment 1 that we just approved, that you just approved, it included approval to expand micrositing corridors from 4,500, and those are approximate, to 14,000 acres to allow additional flexibility in siting of facility infrastructure. Certificate holder council approved authorization to expand the site boundary by 74,000 acres, including 10,000 acres of new micrositing corridors and approximately 64,000 acres of other lands leased by the certificate holder. So that is a 74,000 acre site boundary with 14,000 acres of micrositing areas. So for that project, we didn't say you have to go out and do wetland delineations for that 74,000 acres. We said you got to do it for that 14,000 acres though. You have to do those surveys for the areas where you might put your facility components. So for any time that there's a survey, you survey the micrositing areas and the other expanded site boundary, because our definitions for analysis area are associated with the site boundary, but we're satisfied with, say, under structural, it's categorizing the structural, hazards. Right? Like we're okay, like do that with like desktop analysis, right? Like I'm fine with that. Same thing with characterizing soils. You can use just NRCS to go out there and knock over a nameplate. As I talk with my hands. Anyhow, so I want to make that clear, and that's another example that we just did. So that's kind of being responsive to this issue. So that said, and as we talk about in the order, in the DPO, and will be in the proposed order, there's an entire section where we talk about all of this. We explain the basis, but the point is this request doesn't have a standard or a statute, right? It's kind of evidence-based. Did Idaho Power present enough information into the record to support the analysis areas, that they were properly evaluated for resources that we look at for each council standard, which all of that is presented in the draft proposed order, right? To where we're going to be looking at like surveys, et cetera, within the micrositing areas and a bigger desktop analysis of the larger site boundary. So we recommend that this, is approved because it's a information. Did they provide the information like everybody else did? And they did. We're recommending that they do. I'm going to pause there. I have a process, like talking about the amendment determination review issues raised associated with that on my next slide. But does council want to talk about this at all, or anybody's comments?
Councilor Byer.
Chair Howard, if I might, so site boundary, we do expanded site boundary, we do a desktop analysis, if any, for resources that we have standards for. Then within the new micrositing area, we would do more detailed surveys if required. So say within the new micrositing area that some protected resource shows up, which it shouldn't because we've already done a preliminary study area, presumably. Would there be any new conditions that would be triggered by that, or?
Well, that's
I
kind
mean,
of what
so-
we look at with this, which is interesting, on whether or not these changes in the additional micrositing areas by definition necessitated an amendment, but we didn't change all of our existing conditions capture anything that would be found in any of these areas. So, no, and I'm just like, and Sarah, you can, I don't, we didn't change anything. I'm looking over here, Sarah, for the people on the phone. We did not, with respect to anything found for the RFA2 areas. Yeah, okay.
The existing
Conditions.
apply.
Yes, except that the nuance there is that we are also proposing to change the T&E mitigation conditions, but that's less so because of this instance and more so because of ongoing coordination with Department of Ag, plant program and the certificate holder, and just figuring out a better mitigation, frankly, something that's actually going to really like work better for everybody, including the plants. So yeah. So yes, but you're spot on with that. I guess, I know what the other thing was. So because, and this was also very blendy with the, like with the position that, whether or not we're going back and looking at the approved facility and opening it up, which we agreed we aren't. We can't, not by their rules. Here, I just have pulled up, this is your structural condition. And you can see here that the change is I struck out site boundary and I said, and we're adding in micrositing area. And so in a sense, this does apply to everything. If approved, it would be RFA2, RFA1, and ASC. So in a way, it applies to everything, but all this edit is doing is tying this back to the areas that are surveyed. All this is saying is you are not surveying that huge expanded area out to the yellow. Like that is a ridiculous amount. Let's go back to Wheat Ridge. Is it 74,000 or 14,000? Which I'm sorry, 14,000 acres is still a lot to survey for everything, but whatever. That's up to them. So over here, all we're saying is rather than doing in that instance of that condition, which is the geotech work, you don't have to do it out to that big site boundary, but you do have to do it in applicable places in those micrositing areas. Whichever micrositing area you choose, you got to do the surveys. So any condition change that where we struck out site boundary and put in micrositing area, it's just like, it doesn't increase or decrease, change what is surveyed. The same area, we're just calling it something different. So that's what those changes mean. And there were comments raised on these changes. So that's all it means. It's because we're separating these two originally in the application RFA1, micrositing area equals site boundary. We're now separating what those areas look like. And so we're just making it evident that, the original area, micrositing area, is what would need to be surveyed. Okay, so now we're, in Idaho Power, Mr. Stipple in the response to comments at the hearing, talked about, siting a transmission line is hard, right? You're working with landowners, you're trying to avoid resources, there's noise impacts, there's sage grouse, there's protected areas, there's utility corridors, there's agricultural pivots. It's not easy. It's not an excuse to, unnecessarily impact anything, but you move a transmission line over here, to appease one resource or person, and that's inevitably, there's very few win situations. So, Idaho Power is expanding this site boundary to kind of get ahead of, so all of us aren't sitting in here for Amendment 27 of the V2H site certificate to move a road 200 feet, right? So that's kind of like the generic example we've been talking about, The intent of expanding the site boundary is that does actually open them up to use, I'm going to say ADR, the ADR process, because it is possible. If a future change, if it doesn't impact any resources, if it is, within the site boundary, but outside of one of those approved micrositing areas, they can submit an amendment determination request, which has its, requirements. And then in our processing of the ADR, we're going to look at the 3 coulds, right? But this is also something that Idaho Power is going to be looking at in their determination of whether or not they think it's going to be a successful ADR. Is there a resource out there? Because also anywhere for that road, they're moving 200 feet. They're going to have to do their surveys, right? And provide that. So that's going to tell us if there's any impact to any resources. Is it going to change any of those conditions? Or is it going to require a new condition? So that's what we're going to look at. Now, we also heard from lots of folks about their concern that this would give Idaho Power free rein to just move things around, which it doesn't, right? They're still bound by process, but this does open it up for them, particularly in circumstances where the landowner wants something moved around and they're doing it to work and appease with a landowner. It's kind of, it expedites the process more. So we aren't sitting here talking about something that somebody wants and that doesn't have any impacts. So the certificate holder represents in response to people who raise this to kind of memorialize its intent to coordinate amicably with landowners in these circumstances. For any future ADR, they would submit this, a landowner kind of consent or affirmation letter. So, which this is one of those things we could, that's fascinating to me to talk about, but I know time. Okay, right. But like, it's interesting what are conditions that come from their origin as a representation rather than imposed to meet a standard. And there's a big difference because actually, I would say for a lot of our facilities, the conditions we have are because they said they would do something, because it's actually not really necessary to meet a standard. Here, I don't know if we would be able, if your process, if we could ever require something like this. So, but to me, this is responsive and addresses those concerns of folks associated with this change.
Kellen, could I just step in?
Please do.
We're after lunch. We're all getting tired, right? But this point that Kellen's making right now is really significant, right? Because one of the concerns that you've heard expressed from the public, I think, arises out of a lack of understanding of the FSEC process. And what Kellen is explaining is the public has said, if you guys do this, then Idaho Power can go and they can now do whatever they want within the site boundary, and they won't be bringing it back in front of you for review or to the public for comment. That's not the case. The important part is our amendment process, as Kellen has pointed out, in 345-27, 350. If something that Idaho Power wants to do within that site boundary, if it could result in a significant adverse impact that you have not previously considered, hasn't been surveys, you haven't analyzed whether it complies with the standards, they have to come back in for an amendment. So I just want to make sure that you're understanding that.
Secretary Cornett, and thanks for the emphasis.
For the record, Todd Cornett. So we're going to all add on to this. And so my add-on is getting back to the amendment determination request process. So we haven't seen one of these in a while, but if you recall, and Councilmember Imes and possibly Councilmember Devlin have never seen one. So it's a way for somebody to say, hey, we're going to do this change and we don't believe an amendment is required. They have the burden of submitting that and proving that to us. We, the department, have the burden of evaluating that, and then we have to bring it out to you. So even if in this case, Idaho Power says, hey, we want to do this change, We don't think it's going to trigger an amendment. We've looked at those 3 coulds. They submit that to us. We look at it. We believe the same thing. We have to bring that to council. We issue our amendment determination request, and at the next council meeting, I have to bring it before you. And if any one of you believe, or even if you just say, we think this should be reviewed by council, you can then trigger the amendment process by yourselves. So there is a lot of filter and a lot of evaluation. So it isn't this carte blanche ability just to move out from micrositing corridor into the site boundary. There are numerous filters in terms of what the thresholds are, but also in terms of the steps in the review processes as well. So I just want to make sure that you understood that. And so go ahead, Kellen, you wanted to,
Thank you.
just showing that.
Oh, please.
Quick question.
Counselor Byer.
If an applicant requests the ADR, is there opportunity for public input in that process? Even if
We
it
we
comes
noticed
to
the,
council?
yeah, we provide a notice, we put it on our website, that's also
Yeah.
brought up in front, but it's not there's no comment period, there's no opportunity for the public to challenge that.
Yeah.
It's only for council to either agree or disagree.
Yeah, based on staff review of what the applicant has presented.
Correct.
Got it. Thank you. So it really could streamline things a bit in limited circumstances. Got it.
But somebody could comment on a public comment period on it, like at the same council meeting. Mhm.
Thanks.
Yeah, I mean, certainly council could, if you wanted to, solicit public comment, but it really is, looking at those standards. Does it, can you go from the micrositing corridor into the site boundary? Yes, theoretically, as long as it doesn't hit the 3 coulds. And so that's where that gets evaluated. You could certainly seek public input, but there's no, and I know a lot of these things are not as, absolute, but it is essentially a threshold question of whether an amendment is required.
Thank you. Awesome. Okay, so I'm moving on from expanded site boundary. Except again, we're moving on, we're gonna talk about other topics. And you do, this, it's kind of blendy in there with some of the other topics. So, all right, so let's go. Now we're back to protected area, right? And this is Susan Gear's comments. And so this is associated with, right, so now we are looking at, the changes in RFA2. Again, her comments are kind of blendy with what was previously approved and RFA2. But she argues that a wetland within the Glass Hill hasn't been properly delineated and therefore impacts have not been evaluated. And this is one of those things, even though the RFA2 micrositing area doesn't go into Glass Hill, when we talk about things like, impacts from construction or, like weeds or in proximity, we would look at it. So we reached out to DSL, who confirmed, one, that the study area for wetlands is the area, in this case would be within the micrositing areas. So that's like the study area. The only areas where something might be located need to be evaluated. So DSL confirmed that the area was delineated in their most recent wetland delineation, and that also based on the National Wetland Inventory, the portion of Wynn Meadows is outside the study area. So that's an example of consultation that we would do. The maps here aren't exactly a one-to-one. This is bigger than this over here, but this is Wynn Meadow. Right, and so that meadow is this right here. This is from DSL. This is their wetland stuff. And over here, these are the areas that we're in, there's that transmission line route, which is outside the protected area right here. Okay. So So there was question raised about so in council's new protected area or revised protected area standard, you added in, notification of land managers. And so now certificate holders and applicants provide the contact of who the land management agency is. And so Susan Gear, said, the Blue Mountain Land Trust isn't the primary contact. Joel Rice, the landowner, and she are the primary contact. This is this is one of those where we've contacted Blue Mountain Land Trust. You just kind of the standard does say, the land management, agency. I don't know if it's intended to be the underlying landowner. So this is one of those things that we're looking into. We haven't heard back from Blue Mountain Land Trust. However, we do have an existing condition. It's a protected area condition. I don't know what, I'll ask Sarah, could you know the condition number? Oh, it's right in front of me. Ha! Oh my gosh. Anyways, okay, well, I don't need to, we'll stay here on my presentation. But this is a protected area condition, and one of them, it's kind of like coordinating with, because there's Ladd Marsh, the previously approved facility associated with Ladd Marsh has a notification to ODF and W, and we suggest adding to that condition that just says, coordinating, document that you attempted to coordinate with the land management agency or individuals. So, and that would be specific to, the provisions in the noxious weed plan, which already requires coordination with landowners. There's landowners, working with landowners is ongoing. Some landowners are working with Idaho Power more than others. This is all part of our tangential pre-construction work that we're working on. So, attempts to coordinate with landowners is ongoing, and this would be, part of that. So we're just kind of talking about, these are the activities, this is the schedule, these are the activities that are happening, these are the, what our treatments or mitigation measures are, and trying to get feedback from folks. So our suggestion is to add this into that condition, even though it would already be required in that noxious weed plan. So does council have any thoughts on that? Do you think that having it just live in the weed plan would be sufficient, or do we want to add to a condition to be more responsive? Let me pull up that condition. And it's okay if we don't, if we're like, you don't need to, we can look at it, later too. So this is the condition. Oh gosh, okay, there it goes. Okay, coordinate, right? So coordinate, it'd be very similar to that sub A. Maybe even just adding, coordinating construction activities. Well, see, this is in Ladd Marsh. I'd probably add on a C, but again, it would just be, we're trying to limit our conditions and not have duplicative conditions or conflicting conditions, in which case, but it also, if it makes it clear in one area that it is something that should happen, maybe that would be helpful. You just want me to move on? We'll think about it? Or do you want to weigh in?
Yeah.
I have a question. I think you kind of touched on it, and that's the definition of a land manager.
Mm-hmm.
And there might be some just gray area there.
Mm-hmm.
Does that affect your, potential condition and the way you word that?
It would, right? Because, well, and also I would suggest just saying, documenting attempts to. I try to be really mindful with conditions to not get somebody in a pickle if nobody picks up the phone on the other line, right? So it's at least being or if somebody's not going to work with you, just show us that you tried, right? Or if somebody is working with you, show us where we ended up. So, if we never, so we're gonna look and see who the contact is. So it's interesting because Joel Rice is the underlying landowner, and Idaho Power in the noxious weed plan, and for, under other conditions like the agricultural mitigation plan, which I don't know if he would, I'm looking at Sarah, she's gone. Because I don't know if he would fall underneath that one, but there's landowner coordination specific with the landowner, which he would be, he would be part of that, which is like already being done or attempting to be done.
That's kind of, I bring that up. I feel like maybe there could be some added definition behind land manager. And then that would help give direction to that area.
Well,
Because if
yeah.
you say you have a landowner section already, there's a specific instructions for landowners, and then here we are talking about a land managers. Because when I read land manager, I think of an agency.
Me too. That's what I think that was kind of the intent of the change in the standard. We could look, this is what we're going to kind of look into, but that's why, and I think that's why Idaho Power said, yeah, Blue Mountain Land Trust. And we were like, well, yeah, because it is. I think the intent was we were looking at BLM, ACEC's area of critical environmental concern, and, areas managed by ODF&W, like so I think that is the intent, and that's what I'm not quite sure how to pack away Susan, right? She's saying we're the land managers. And I'm like, well, right. But like, you still had to have kind of like the hosting, going through the process of becoming a state natural area. It's a process, right? And so it kind of went, into its, conservation easement, et cetera, like management, what designates the management of that area is through the Blue Mountain Land Trust, if indeed that's what it was. And we can, we're just going to look into it more. But in that sense, it doesn't make sense to then add a condition, I don't know, like can't get a hold of them. So, what do you do? And so if the landowner, maybe it's sufficient just as it is, because landowners they're required to work with the landowner. And if, Susan Gear and Joel Rice are contending that they are the ones that do the weed treatments and manage the land, there's already the requirement that they coordinate with them. So I don't know. I guess it does kind of go in. We need to figure out what that means and who the agency is. I think I'm not sure, I'm not sure we're going to be able to find a conclusion on it, frankly, unless we can get a hold of them. And I think the intent of the standard is to designate kind of the agency. So I think it would be Blue Mountain Land Trust. In which case I think it would be more important to work directly with the landowner like they already are required underneath the land management plans, but we just wanted to be responsive to it. So we're going to try to get confirmation from Blue Mountain Land, from somebody who's there. So we'll look into that. We'll see where we land, and then we'll see where we land. But the important thing is of what, Susan Gear's raising is that, Idaho Power is already required to coordinate with landowners on like weeds, and, or just construction activities in proximity to sensitive resources, which also includes T&E plants, and wetlands, also just with respect to wetlands, the required area to be delineated is the area, those micrositing areas. And there's, a list of conditions, because this project does require a removal fill permit, which is under council's jurisdiction. And, we can impact wetlands. That's like, Idaho Power's trying to avoid them, and it's fairly easy with like tower pads and whatnot. It's mostly construction activities that might impact them. However, they have this whole, off-site mitigation site. It's all very articulated and worked with DSL. So that's just, wetlands aren't a complete avoidance. The preference is always to avoid them. So, but yeah, the intent is to coordinate with landowners to avoid, minimize, and minimize impacts to resources on their property. So. So we'll see. Yeah, again, we'll look into it. And again, this is us talking about it. So even though this says this here, we very may not end up changing that condition. Okay, another one of Susan Gear's issues is, I'm not going to pronounce the scientific name, but this is the rough goldenweed. She contends that it's known to occur in Morgan Lake Park and that it's on its way to the Oregon Biological Information Center, or ORBIC. And that's kind of the repository where one would go to find the location and list of threatened and endangered plant species. So, and then this is one of those, we're still working with Oregon Department of Agriculture, because there's a process, right, by which something gets kind of on the list for T&E. So Ms. Gear's actually the one who submitted the reports to the Oregon Department of Agriculture about the, location, existence of the rough goldenweed in Morgan Lake Park. Oregon Department of Agriculture, initially they're just like, doesn't seem likely, but they're going to look into it more. And the only known occurrence of the species is in Wallowa County. And one of the things that we look at under T&E, if there's not, we talk about suitable habitat for the species, and then whether or not the species is actually there. And then I believe the certificate holder and their responses to this comment are, that, even if it was, our existing conditions would capture and cover any potential impacts to those species. But I think right now we're just in a position that it's not, we don't have any, there's no facts that say that indeed it is, or that, and it would have to be reviewed on whether or not the report she submitted, it is that actual species located in Morgan Lake Park. Okay. This is a teeny little picture here. I'm going to go to, where am I going to go? What is this called? Condition 8. Where's the coding for that condition? Okay. Oh. All right, so we kind of air quote opened up retirement for RFA2 because we added on the midline capacitor station, and it was just different, which actually was a really good opportunity because, the last retirement, mostly this is just like administratively, we've kind of have not changed. We've been doing it pretty consistently, but we have a kind of like our spreadsheet, like Cal Council looks at retirement, how we break things down by component, how we like the units that we like to see. It helps us process to make sure we're capturing everything in our retirement cost estimate. So having the midline capacitor being added, it gave us the opportunity to kind of update that format, but also get updated unit costs, check the box, make sure we got everything there per facility component that it would be retired, and then add in that midline capacitor. So we're going from, right, and underneath the scope of council's review, it's whether or not the amount of the bond or letter of credit is sufficient. We went from, 140 million to 170 million. Most of that is just by updating those unit costs, right? It's functionally, that's kind of like adjusting, which already would have been done prior to construction with the previous unit costs. And then there was some minor increase in adding on that midline capacitor. So that was the total. And now we're kind of going back in time. Again, very litigated issue because it was a unique proposal. And what a proposal in the application, what council finally landed on in its final decision is unique to this facility because it's a transmission line, which is a utility facility necessary for public service, which is also regulated by the Oregon Public Utility Commission. as opposed to other facilities that council reviews, like solar facilities and wind facilities. Those are private developers. They're not a public utility. They are, they have other laws and regulated in different ways, but utilities like transmission lines are, heavily regulated entities by lots of other entities. So that is kind of one of the tiers that supported council's approval of, it's basically the $1 bond, right? So I'm going to go back to my slide here.
Mr. Chairman?
Yeah, Councilor Devlin?
Just a quick question, and I think the speaker has alluded to it. There is an issue with transmission lines, probably outside of our purview, which is maintaining those transmission lines. That obviously has been a significant public issue over the last few years, and not particularly for Idaho Power. Don't know of any issues there that are that significant, but that would be an item that's regulated by the PUC, correct? They would have authority.
What type of maintenance, or like what example are you
Well, one
of?
of the issues on power lines, like in not the PGE, but the PG&E system, is that perhaps some lines were not as well maintained as they should have been, both in terms of the condition of the lines, conditions of the towers, and also in terms of keeping the lines away from possible fuel supplies.
Absolutely. Nope. And you're correct, Councilmember Devlin. And you see that kind of woven into like Stop B2H's comments and Irene Gilbert's comments with respect to the bonding. Kind of the premise, totally paraphrasing here, is that, like this what you approved is risky, or you need to change this. It's risky because, for example, look over here at PacifiCorp and, like the cost of their litigation and settlements from those fires is putting them into a financially unstable position. And the same can happen over here. Again, totally paraphrasing.
But at the same time, what I'm saying though is that the Oregon PUC has ability to regulate those public utilities, and as part of that, their transmission lines.
Yes, absolutely. And we're going to talk about that a little bit later, because I am going to talk about wildfire. And you have that ability too. We are regulators after all, and we have several conditions that address ongoing maintenance, inspections, reporting, vegetation clearances, which a lot of it would be duplicative with a lot of that stuff in the wildfire mitigation plan. But we have we have a lot of those. And we have our own compliance team that is going to be doing inspections as well with the PUC. And again, I'm going to touch on that, and maybe we'll just kind of let's see if we have any outstanding questions when we talk about wildfire over there, because this is all related, right? How will you maintain a transmission line is going to reduce the occurrences of any emergencies, particularly fire, right? So we're over here with bonding. And really, I mean, if it's taken 15 years for us to get to this point with this transmission line, I mean, basically, and I think that we could agree, like Oregon hasn't constructed a large transmission like this in, I don't know, Todd, what do you think, 50 years, 40, 50 years? Right. And it's taken about 15 years to get to this point, and there's not a transmission line built out there yet. And I think it's reasonable to assume, the assumption is that if it's constructed and put into operation, that it would be on the landscape in perpetuity. And frankly, as much as all the conversation about needed transmission and shortage of transmission, I think it's safe to say that the lifetime of the facility could at a minimum be 100 years. And that's what we're saying. Basically, once it's put into operation, the likelihood of that thing not being needed is very low to none. That and PUC regulated entity, they have rate recovery over there. Basically, what council agreed upon is, from construction, it's a 4-year construction period where we increase to that 170 total in quarters per year to reach that maximum total during construction. So the more facility you have on the landscape, the more money you would have in your bond to remove it if it doesn't work and it needs to be removed. And then during operation, we would go dollar bond up to year 50 and then go into the full, the total of the bond. And what we recommend, we don't recommend changing this condition aside from what we've recommended here of updating the quarter and the total. But we do want the Idaho Power in their responses, right? Like added some, like to me, some supportive supplemental information. They gave some cost estimates of like how much it would cost just maintaining the bond for these years, which essentially is just a cost that would be passed on to the ratepayers, So anyhow, so we don't recommend making any changes. Oh, yeah. And I have it in here. We talked about this at length at the approval that we're every 5 years. I'd have to look at it. I don't know if it's triggered. I think Idaho Power submits a report. Like we basically, right? Like, is it right? Because that's one of the contentions of the commenters is like, this is an outdated technology and there's different things and, like what's out there and also what's happening in the market and what's their financial status. And so every 5 years, they're going to provide this report with some of that information. And also same thing that we're kind of adding into this template condition, which is, this is our interpretation of the mandatory condition. Taking the mandatory condition, just lifting it as it's stated. It's one of those things where you're like, what do I do with this? This isn't helpful. So, but we've added in the council, you can open it up at any time. You retain the authority to adjust the bond at any time. If anything, if you're worried, if there's a concern, like if there's a worry, we can open it up. Okay. So noise. Noise. Okay. So this slide is just a synopsis of what happened with what we did in RFA 2. So we had several different transmission line route changes, right? And we're talking about operational potential for corona noise. And all of the modeling for corona noise is under what we call a worst case scenario, which is it has to be really quiet. So it's the middle of the night. It's under peak weather conditions, which is called foul weather, which is a very light rain. And it's with just low ambient noise, right? So, quiet, low wind during foul weather. So these are the modeling conditions to get what may be a potential exceedance to the DEQ noise rules. So we, certificate holder applied same methodology that they've done for RFA 1 and the ASC, which yielded that there's 27 NSRs that might have an exceedance to the noise rules, which is anything more than 10 dBA per hour above the ambient. And 7 of those were a new NSR location. And an NSR is noise sensitive receptor. And that's basically residences. It's places where people normally use for sleeping. So the change to the condition over here is, and I know it's small, but it's fairly simple. We're just adding in those NSRs. And this is the condition that kind of identifies who's getting noticed, who Idaho Power is going to work with on mitigation agreements for noise mitigating materials, etc. Okay, so that's what happened. All right, and then we have noise came up, heavily in Stop V2H's issues, and a lot of it goes back to the methodologies there, and other folks, I believe, Wendy King and Sam Myers raised noise, as they're saying, this 1978/83 sound, the MPCS sound DEQ sound manual, the methodologies, and it needs to be used to establish what the baseline noise is, and baseline needs to be established at each NSR. They're maintaining that the mitigation in the condition, in that noise condition 1 is not only not sufficient, but it's or actually I think, but that one, it was not sufficient. But then they contend that the noise complaint response plan is not only insufficient, but it's bureaucratic, hard to follow, too convoluted. And again, I'm paraphrasing for exactly what they raised. We could see their comments, or look at it in the staff report table with our responses. And I know this over here isn't intended for us to read on the slide. I pulled this out of the staff report. This is where I did go into a little bit more detail about this was it was really one of the most heavily litigated issues, particularly when we're going into expert witness and direct testimony. Idaho Power actually went back out onto site and collected more noise data, as did Stop B2H. The point is that really for this, one of the things of Stop B2H's positions back in the application was that council didn't have the authority to evaluate and grant a variance or an exception for these noise exceedances. That was their position through the whole contested case. And what they did is they said, this is our position, but we're still going to argue these other issues, and particularly into getting into back and forth about the noise conditions. They still participated fully in those, but their overarching position is that you don't even have the authority to do this. Ultimately, that went to the Supreme Court, and the Supreme Court said, yes, you do. So you do. So that's not this argument, but now we're going back into how the data was collected, mitigation, and the complaint responses. So really this sound manual doesn't contemplate a large linear facility, crossing 373 miles in Oregon. And so, in the years of developing the noise methodology and the use of our consultants and noise engineers, we basically determined that it was appropriate to use baseline monitoring positions that were representative for NSRs or residences within the same acoustic environments, right? Rather than going out and measuring a baseline at each house, hundreds of them, right? We're going to group them together, and that was appropriate, and we described why, and that was litigated. So, and that the sound, it's old. It doesn't work. It's not, it doesn't contemplate new technology and, calibration. Anyhow, so we really looked at that. And then the kind of the point with the mitigation and the complaint response plan. And I think Patrick, I don't know if he's getting the shakes over here from from talking about noise in the contested case, but we did. And particularly with the conditions, it was back and forth, which finally resulted in the hearing officer's contested case order, which after that was issued, which that was done of contested case of that a year and 10 months. And then parties to the contested case were allowed to file exceptions to that contested case order. And so they filed, there was a lot of exceptions. It was a lot. And so we traveled out to LeGrand for 3 days of full days of exception hearings where we went through all of them. And at one point in time, when we got to noise, both department and Idaho Power agreed that the hearing officer maybe missed an opportunity or didn't consider some of their changes to conditions, to the noise conditions. And so we sat down. And so when I say Stop B2H was at the table in the development of these conditions, it was literally at the table at this exception hearing where we're going through back and forth on the specific language of these noise control conditions. So, and we have the conditions that we have, which the only change to the condition for RFA 2 is making sure that the other NSRs that might be implicated are included in the mitigation, notification, complaint response plan. Stop B2H did say with respect to monitoring that we had this one condition and this NC03. It's the one that says the transmission line's going to be like triple bundled. NC03. Oh, it didn't go. Nope, no, I don't have my Sarah, and that's okay. That's fine. I'll find it. Oh, oops, great. And now I just wrote in my staff report. Okay. You know what? I put it in my staff report. I don't know if you saw that or not. Thank you for your patience. This is gonna go so fast. It's gonna go so fast after this. Okay, well, this is a condition. I don't want to waste our time, and you will see it. There it is. All right. This is from the staff report. So it said, the condition said during construction, you're going to implement these design features, and it's triple bundle your line and then maintain tension on your insulator assemblies, and then protect your conductor surface to minimize scratching and nicking. So Councilmember Devlin, this is kind of one of those things. This is a maintenance condition that probably is already duplicative with other requirements and things that they'll be doing or say that they need to do somewhere else. But this was based on their representations. And to me, like, and looking back at the final order, its intent is to be a construction and operation. If you're constructing it, you're going to construct it with this triple bundled, but maintaining tension, that's an operational thing. So we're suggesting just making this, rather than a construction thing, it would just be an operational, or we would change it to a gen condition, which applies to multiple phases. And then we also point out, like, that's not it. Like we have lots, which Councilmember Devlin, this is also talking about what you were talking about, right? Like we talk, utilities and transmission lines are heavily regulated, right? So that's regulated by, NERC has standards, and then the OPUC, and then we have conditions that require compliance with and reporting of outcomes of their transmission maintenance and inspection plan, that TMIP. So we have conditions that require them to report that, and so that's also part of your record, are all of the representations of operational maintenance in that TMIP. And then with respect, because Stop B2H is talking about, line sag over time. Don't I have it in here? Maybe it's, oh yeah. We also have this citing standards for transmission lines, which has minimum ground clearances for under maximum load, maximum heat situations where there would be the most line sag. So so that's our recommended condition change, just to make sure that it's evident that that does indeed apply to construction and operation. Does anybody have any questions about some noise? Oh, wait, no, yep, no, that's, yes. All right, okay. Noise, make some noise. Woo! Stretch, we doing okay? Do we need a break? So excited, we're doing okay? Keep going, all right. All right, so wildfire mitigation plan, I want to bring this up because I know council cares about wildfire. We've been talking about it a lot. And this again is unique. This transmission line and the application of the rules is unique for this facility. Why? Because underneath your wildfire mitigation standard, you have a sub 1, which is what you've been seeing for all of these other facilities, and council has been, you've been doing your own WMP for construction and operation, right? And so we're kind of and I think we're going to talk about it more, and I think we're getting to a good place where we're on the page about what that looks like. And your standard does say that council may, under sub 2 of the standard, if there is a facility that is, regulated by PUC and required to comply with the PUC wildfire mitigation plan rules, that, council, you don't have to make those findings underneath one. Basically, you adopt their wildfire mitigation plan. And that's what we suggested. It's like, it's approved, they are regulated, they are required to do one, and there is an approved one, and we're there. And I would say that I'm not putting down I feel comfortable with our wildfire mitigation plans for our other facilities. But these things are like for transmission lines, and it's not just transmission lines. These are for utilities who have like a whole slew of assets in the inside and outside of their service territory. Under the PUC's rules, they have to submit a WMP annually. It's basically in a constant review cycle, right? So they submit it, and just generally speaking, and so this is just like, we're maybe in the third year that their rule has been in place. So this is all very new for everybody. So if you're feeling like wildfire is new, it's still relatively new for everybody. So they do an annual review to where, and there's lots of, it goes into a docket, and there's lots of public participation, and comments are evaluated very much like we're doing here and respond to, et cetera. And then the staff makes, ultimately, the PUC approves it, oftentimes contingent upon a staff report and recommendations to do blank, blank, blank in next year's wildfire mitigation plan. They have taught, the intent of it is to be iterative, adaptive, and responsive. And so they're in that pipeline. So I'm having this slide, and I don't know if you notice these details. It doesn't say issues related to. I'm just talking to you about, like, this is just an interest, this is your review of the DPO, and I just want to talk to you about the wildfire mitigation plan because it's interesting and it's different from what we've looked at for these other projects. Wildfire was raised by folks, particularly like Wendy King and Sam Myers, and they say, our family has concern that RFA2 is not in compliance with the new wildfire MISC standard because the lines routed through Butter Creek wildland urban interface. And Sam Myers says this plan is frankly unacceptable and leaves out significant cropland impacts from fire. I would say I don't know how to respond to either of those. Like it's mentioning a standard, but I don't have any. How is it insufficient? I don't know. I don't understand. I don't really have a good way to respond to that. Idaho Power provides responses, and I suggest that, just making, weaving in some of their responses into the proposed order, just to again, help tell the story. I think, emailed back and forth with Councilmember Imes about the WMP and questions with it. So they actually added this, right? And this is Councilmember Devlin, right? So OPUC, there was a question about field compliance. Does PUC actually go out there and inspect the line? And yes, they do. So Idaho Power kind of clarifies that. So OPUC annually evaluates the vegetation management programs and every 3 years inspects vegetation as part of NESC inspections. And so again, and you council, you have our own, reporting compliance, inspections, maintenance conditions, and all of that gets reported to you. And then we have our compliance program where in our rotation, we would be going out 1 year or more to check on various site certificate conditions. Okay, yep.
Councilor Byron.
Just a quick clarification. So for transmission lines, we're defaulting to the wildfire mitigation plan developed for the PUC, which makes a lot of sense to me. And then with the RFA2, is there any language there that says that this plan will now include the new site boundary micrositing area? Do we have to make that explicit, or we've said do this as part of the site certificate? Do we need to say, and by the way, that extra stuff we just added is covered?
You mean a change to the condition or just in the order? I don't think you need to.
I don't know if you need to change.
I don't think you need to change it because in the well, in their wildfire MIG, right, you're like, our analysis area goes out, a half mile, I think, right?
We've already approved that.
Right.
We've already said this.
Yeah, and then
applies.
their evaluation and their plan also has this buffer, which would be covered in,
Okay.
would overlap with your analysis area. So I don't think that we would need to change anything,
Okay.
but that's a good question.
Thanks.
Chair Howe.
Yes, Councillor Imes?
Thank you for bringing this up
Mhm.
today and talking more about it. I would like to see, I know that the 2024 should be coming out anytime. I would imagine going before OPC.
Mhm.
And then it would be filed with us at that time, correct? And, was the 2023 order in our review of this amendment?
Yes.
Okay,
Right, so this one is part of RFA 2 to demonstrate continued compliance with the standard.
okay. All right, and then, I guess I'm also wondering about compliance capacity, but it seems like, the Public Utility Commission is going to have quite a bit of an impact on compliance as well. But I'm talking more about like the capacity for, the siting division. And like, once this is actually comes, to fruition, have you guys thought about what that really looks like for this department? And if there would be any needed staffing for that or not?
Well,
Just out of curiosity.
yeah, no, I think it's really, it's a really good point, and thank you for thinking about our staffing. I know, Secretary Cannett thinks about it all the time, same thing as Senior Policy Advisor, Esterson. It's interesting because we have a lot of facilities. We have a lot, right? But not every facility gets built. But we're kind of thinking that we're going to have kind of this big push of construction of a lot of facilities. And I'm sure, as Sarah Esterson has mentioned, we have Haley Aldridge, our consultant, on board helping with compliance. You've met Ash Woods, our new compliance officer. Like, we're building out our compliance program. That said, construction is the big, right? It's the push. It's real impactful, kind of all over, and it's a big draw on resources. That's not to say that operation doesn't. There's not like there's a lot of operational work. A lot of it is reporting and like the site visits, but really, once you get into operate, it is a drop down as far as like pulling and that's when it really kind of goes over into the compliance program and reviewing the annual reports or any incident reports and scheduling the on-site stuff. So to me, as far as like, it's more manageable because we can schedule it out. I don't know if Secretary Cannett wants to add anything on that, but except that we are being mindful of our staffing and trying to staff up to accommodate all of our work.
This is an opportunity to talk about it because, again, they are expanding here, right? At the end of the day, this is an expansion.
Yeah, I mean, in terms of RFA 2, I mean, it doesn't. It's not an expansion. The facility is already approved. So this may change
Gives them the opportunity to expand.
well, but I mean, it's still going to be, a 300-mile long line and has multiple route alternatives at the end. If it gets constructed, it'll be constructed 300 miles. It'll be the same beginning point and end point. So RFA 1 didn't really change that. RFA 2 didn't really change that. It didn't, they're not going to build all of the alternatives. So, I mean, your point is absolutely valid. Do we have the right compliance staffing for the foreseeable future to meet all of our ongoing compliance needs? And the answer is we're constantly looking at that. So, as Kellen brought up, all the things we have right now, we currently have within the proposed budget for starting next fiscal year, another compliance officer. So, we have 2 full-time compliance officers. This would give us a third. We have another vacant senior siting analyst position. We are looking to fill that, which may include some more enhanced compliance responsibilities in addition to the applications and amendments. The difficulty with staffing is we have to match our fees to the staffing. We can't have a bunch of staff that we don't have the fees to cover. So that makes it difficult. You sort of overlay a couple of different things. And I've talked about this before, which is what's the foreseeable work that we have in terms of applications and amendments and compliance, and that, as Kellen said, some facilities never go into construction. So we have to be kind of looking out in the future and thinking, what's that going to be? And, do we have the right staffing? And do we have the justification to have the staffing associated with the fees? Because most of the coverage of the siting division is covered by fees. So it's always a complex thing for us to be looking in the future and then dealing with the biennial budget cycle that the state has. So we are constantly looking at that. And luckily we do have some ability with our consultant to be able to rely upon them to fill in some of the gaps when we need that. So it's a good question. We're always looking at that, and we're always trying to match those two things into the future, what our funding is and what our staffing needs are.
I think that, you've been saying this over and over throughout your presentation, and that there's many things that come together at once and you end up learning from this and gleaning, and that's, I feel like, kind of one of these, the point I'm trying to make is that the cumulative effect and what it really looks like. Is it manageable? So I think it's just a good discussion to keep having.
I
I'm not
absolutely think so.
suggesting any kind of major
Yeah.
condition or anything about that, but it's just, keeps coming to my mind every time I read these, it's just that much more workload, really. So.
And that's exactly why, we spent a lot more time recently on the compliance program, because as new facilities get approved, that means the very likelihood that we're going to have more projects get constructed or go into pre-construction, go into construction, be in operation, and we need to have the staffing to be able to reasonably evaluate all of those timeframes associated with, the life cycle of a facility. So it is a good question, and we are constantly looking at that.
Yep, perfect. And I look forward to seeing the 2024. And I know they do, I'm sure, Public Utility Commission does a very thorough, very, very thorough wildfire mitigation plan. So I'm eager to see.
Absolutely.
That.
It's really it's kind of fun to read their staff reports, right? Because they're like us, right? But different. And so it's just interesting to kind of read to look at how they kind of do functionally very similar, but totally different from what we do. Which is also one of those things, they do have an independent contractor that helps their review, which again is really interesting to read the staff report, because they also often disagree with that. It's just, it's fun, because I'm like, you guys are dorks too. I like it. So that said, about the 2024, so what we have on the record now, and the record's closed, is 2023. That's the last approved one. 2024 is in this cycle, but so say there was never another amendment again. Okay, it's fine, but the rules apply to everybody and you can exercise the rules. No, okay, so totally just joking. Okay, keeping it lively here. We're almost done, guys. We're doing great. So say this was the last amendment and council ends up approving it. The condition, we have a condition, we have a construction plan, fire plan, and then we have our operation wildfire mitigation plan that basically says, before you start construction, give us the last one, and then every year in operation, give us your most updated one. So it's possible that we would have a gap depending on when they did compliance with that condition. That said, we can go on and we can go on and pull it and look at it, but it might be depending on when they go into comply with that condition. If it happens in 2020, well, if it happens in 2025, they would probably be giving 2024. If it happens in 2026, then they would probably be giving 2025. So just, Okay.
Thank you.
Don't, thank you. I know this is important, so I wanted to take some time to talk about it. Okay, so, just can't, because I'm moving on to the next steps. And we're, I slated 2 hours for this presentation, but we can take the time because there was a lot of comments. So was there anything that was on your mind or on your list to talk about that we didn't talk about?
Counselor Byer.
Thank you, Chair Howe. We got comments from, I believe, the Union County Road Department, a very specific list of asks, but it seemed to be very thoughtful in dealing with both the construction phase and the operational phase. And I'm just wondering if, and I think, would that be in the public works standard? It was dealing with all the new or changed roads and the road width changes to deal with slope stability. But it seemed to me that there were some useful things about road maintenance that maybe not necessarily addressed in this project, but to keep in mind as we look at other projects to make sure in our conditions that we address both the construction and operation. And I think they had some specific asks on maintenance, which is, probably well beyond what we need to deal with. But I thought it was a good outline of road people are worried about.
Absolutely. And
so-
Public Works is a little soft spot in my heart. I love my public services. So that said, was some of our agency consultation.
Yeah.
We followed up with Scott Hartel with respect to the ordinance 2007 with respect to entrances to protected areas. This standard is in when applicant's developing a new street. So this is so he's right, like this. So this isn't applicable to this project.
Yeah.
Basically is what he's saying here. And then I followed up and I said, hey, asked about that letter, which had a May 30 date on it, but it actually is a letter from 2017.
So already incorporated.
So it's all,
perhaps
and
in
as you
the-
can see here, because there's a road, our condition says do a road use agreement.
Yeah.
They actually, Idaho Power has already executed a road use agreement and the road, and pretty much, and just to again, keep in mind for every one of our facilities, road use agreements is everyone, and road use agreements, again, I love my roads and public services. And so it's one where they go out and you evaluate what roads you're gonna use, you check the conditions, and it's a legal document that requires maintenance and improvements of roads to their standards, et cetera, and it has a whole bunch of other stuff in it too.
So this was part of the original site certificate, and it just continues to apply to the amendment.
The road use agreement
Um,
or that letter?
This condition.
Oh, this condition. Yes. Yep. It applies to,
And it's up to the county and Idaho Power to update the agreement if they feel like it's necessary. We don't need to deal with that.
Yeah, we would get any updated. Yeah.
Okay.
And what they would be, if it's updated, it would be submitted to us and, if they're changing the roads, yes, I imagine that if they're changing the roads or aspects of some part that would trigger the change in the road use agreement, that the county would re-execute
Yeah, I
one.
just looked at the date and didn't get.
Yeah, no, the date was not, it's not a May 30 comment letter
Thank you.
date. It's from 2017.
Thanks.
Any other topics that we didn't cover?
Chair Howe.
Yes, Counselor Imes.
Thank you. I don't have any questions, just more of a comment. This is my first time evaluating this project, and it's very, very complex. And I applaud you on the way that you present the information, especially for a newcomer. Specifically for this amendment, after reading the comments, became really clear to me that the micrositing versus the site boundary and just how important that is. And you explained it very well in your staff report. I understood right away that, you know, this, if there's going to be any surveys that need to be done, an analysis, further analysis, it would be through the ADR.
Or an amendment, yeah.
Or an amendment potentially. So what I saw from a lot of the comments was really this big concern, right? Because of, and you've already talked about that, but I just want to reiterate from a newcomer's point of view that I caught on to it very quickly, meaning that I understand the reasoning behind, you know, the decisions that have been made and are being proposed today. And again, I just really appreciate all of the hard work because, you know, I know about that much and there's like this much. So again, thank you. And that's about all I have.
Mr. Chair.
Thank you.
Yes, Secretary Cornett.
Yeah, for the record, Todd Cornett, since you brought it up, I was going to talk about this earlier, but I decided not to. But since you brought it up, I'm going to actually make the statement. So if you go look at a lot of our older facilities, like particularly wind facilities, it's really the applicants, basically, they submit what is their micrositing corridor and what is their site boundary. Idaho Power's done something a little bit different here than most developers. They started with largely a micrositing corridor that was the site boundary, and now they're kind of expanding out beyond that to create the site boundary. Most facilities come in with a micrositing corridor and a much more significant site boundary to begin with. So what they're doing is not anything different than what most developers have done. The big difference that they're doing is sort of the sequencing of that. So if you look back at almost all of our facilities, you will see a much smaller micrositing corridor and a much bigger site boundary. So everything that Kellen talked about, you know, we talked about in terms of the certificate holders availability to request an ADR, that applies to everybody else who has a micrositing corridor and a much enhanced site boundary already. So again, the biggest thing that they're doing differently is the sequencing of creating that site boundary, you know, in an amendment versus from the beginning. So that's really, I think, the difficulty that, you know, I think a lot of people are sort of thinking about how this is being done. It's not that it's different than most other developers. It's just the sort of timing and sequencing with which they are doing it. If that helps.
Yeah. And then the maps that show that now big, wide line, you know, that's, and on that, and I just, cause but I want to, the condition that we, it's just like a general standard of review condition. And it's the one that basically lists out what the approved facility is and lists out all the names of all the alternatives. It also cites to the map sets that show that change. And so this is, I'm like, Jim, if you're listening, this is for you, Kreider. So, you know, cause there was concerns that, you know, this change kind of happened midway through processing the amendment. And there are some map sets where refinement of the expanded site boundary didn't happen. And one of them, so there's, I think it's like map set 8-1 or something, does actually show the line going through Morgan Lake Park. I want to make it clear on the record, as stated in the final order on the application, there's no facility components located within the boundary of Morgan Lake Park. This map that you have up here, this figure 4.1 is the citation to the map set that will be associated with what they're approved to construct. And you can see here that not only the facility is outside of the site boundary, but of the park, but also the expanded site boundary does not go into the park. So just want to make that abundantly clear. This 4.1 map set is the one that will be associated with with the approved facility. Okay. So the next steps, okay, we're going to take your comments, feedback, And we're gonna do a little bit more agency coordination. We're gonna continue doing what we do best, and then we're gonna do a proposed order. The proposed order is the DPO, and any changes we do are in red line. When we issue the proposed order, we're gonna issue notice of the proposed order and an opportunity to request the contested case. The rule gives us a minimum of 30 days or 30 days for people to submit those. We're probably going to be pretty close to 30 days here. Now, I know that we get requests to extend deadlines, but I want to make this very evident. This is not another comment period. This is not an opportunity to submit more evidence or to refine, expand, change your issues, right? This is, I love buckets and I love filtering, right? Everything went into the DPO bucket. And now for any folks whose issue was not resolved. So I also recommend anybody who would like to request an opportunity for contested case, read the proposed order, the staff report, your own issue, and be like, well, was my issue resolved or not? And right, like we're narrowing. Any requests for contested case are limited to what was raised. How'd you raise it? What'd you raise? What was our response? And formulate it from there. So that's the deadline. And then like kind of looking ahead and this is what connecting the dots with your rulemaking and just other projects, which thank you, Councilmember Imes. Like it is like, to me, I love this stuff because I love going like, oh man, this is related over here and you can apply this here. And to me, it all kind of comes together. So our threshold. So if you want to any issue for the contested case, so it has to be within your jurisdiction. There were lots of what I focused on in the presentation today were things that aren't in your jurisdiction. So I didn't talk about the many issues associated with how Idaho Power or their consultant may be working with landowners, compensation to landowners, leases, condemnation. That's unfortunately it's out of your, or fortunately, I don't know, it's out of your jurisdiction, right? We look at standards, we look at resources, we look at impacts, organizational expertise, retirement. There's a lot we look at, and that's not one of them. However, we do know that Idaho Power did represent a quasi landowner condition of in any future ADR, they're going to submit that landowner letter, which is nice, right? Like that's going to help. It made me feel better. Because it's anyways, you really want changes that are happening to be because a landowner wants them, or to really like minimize or avoid impacts to resources. So it has to be within your jurisdiction. You needed to do it before the record closed, and here's sufficient specificity, right? So including facts. What were the facts? How did you raise the issue? Did you give us something to respond to? So, and then later on, so what council does for amendments, your threshold, right? It's a lot, we're asking the question that we're answering. So later on, if it issues, because this is also in your continual reading, right? When you read the comments, like, so what in my brain, when I'm reading comments, I'm skipping ahead, right? Like we're parsing, like, this is how you think. So just kind of like, and then in your, particularly with like your contested case rulemaking, just kind of like thinking about all of this. So, right, like, was there an issue raised to justify it? There has to be an issue, a factor law that would affect your determination of whether the facility with that change complies with any of your standards. So, so when we'll deal with those later, if we get any. Oh, okay, now you can deliberate. That was my presentation. I have, like, there's tons more. I mean, Kaplan fell asleep.
Mr. Chairman?
Yes, Councilor Devlin.
Mr. Chairman, for the record, I know we're not making a decision today, but in this particular case, I don't have anything additional that I'd like to see pursued, and I don't have any additional questions.
Okay. Well, I think the rest of the council agrees with you, and great job, Ms. Tardy-Weather.
Thank you. Thank you. No, I know it's a lot, and I just really wanted to take some time to, because there was a lot of questions, but just to do, refresher for all of us, but for new council members, to get you, on board, because it's a big project. People really care about the project. members of the public, opponents to it, you know, the project proponent. So, you know, like it's I want to do it and them justice for you to help your decision making. Yeah. All right.
Okay, is there anything else for the good of the order? Okay, the time is now 2:11 p.m. and the June 14th, 2024 meeting of the Energy Facility Siting Council is now adjourned.
Thank you to the staff and to the chair.
Thank